Yes.
Mentioning one matter, Lordship.
What is it?
The second appeal, Lordship, with a stay application,
The application has to go before the land singly. It has been admitted.
No, Lordship. Urgently.
For admission hearing, order 41. Write order 41 and hand over. Order 41 rule 11 and hand over. Order 41 rule 11. Yes.
These appeals were disposed of, my lord, but there's no direction to send down the trial court records. So I'm praying for two images.
Yes.
I'm grateful.
Mentioning for inclusion, affidavits have been exchanged in February of 2025.
What is the matter?
WPL at your lordship.
Wait for some time. Yes.
It matters for inclusion.
What is the heading?
Order.
Pardon? Please come prepared on it. Yes, call on the list.
No, minor.
What is it?
Application.
Yes, call on the list. What correction?
Lordship, on last occasion,
Yeah.
by order dated 20th July,
What is the correction?
correction, Lordship, para 9, it is written that for that substitution upon here legal heirs and legal representative of sole appellant and pro forma respondent number 2, 3, and 4. It will be 2 and 3. 4 is alive, Lordship.
Yes, right. Thank you. In paragraph number 9 of the order dated July 20, 2026, comma, the expression within double inverted 3 and 4, numeral 3 and numeral 4, double inverted close, shall be read as double inverted and 3, double inverted close, full stop. Let this order be deemed to be a part of the order dated July 2020.
Lordship, in para 11 also. Sorry, Lordship.
Same.
Yes.
ওই ইয়েতে যেখানে বললাম in paragraph number 9 and 11 of
লাস্ট অর্ডারটা কিন্তু নেই 20th জুলাই এর অর্ডারটা
এখানে
আমার দেখতে ভুল হচ্ছে কিনা একটু দেখে নেব
না ওপরই তো থাকবে দেখবেন এগুলো যেন না হয় নেক্সট করে দিন এটাতে ঢুকিয়ে দেবেন এটা
item number 2
Lordship, I am on behalf of the read petitioner, respondent number 1.
instruction
Dismissed teacher.
that instruction yes
Lordship, I have taken the written instruction.
file it din
Permission I am filing.
permission granted let us look into it give a copy to them very well 5 এ বলছে এখন আবার জব
কপি দাও কপি দেবে না
very well. We are keeping this on record.
I don't know
They have stated this again jobless. Joined a school. 2 schools in the interregnum. Drew net salary such and such. From 16th July 2013 to... No, I was... Sorry. Oh, I am presently unemployed.
Lordship.
No, you are not employed in some other school which was named there.
Lordship, after this result, I joined in other schools, but presently I am...
No, a third school was named in the... Your name was featuring as an invigilator. Huh?
Joan
St. John's. What about that? What about St. John's? The records indicated that you were...
he came to our school
Yes.
as invigilator from that school
Right. So what about that? আচ্ছা yes.
তারপরে সেটাও গেছে সেটা এখানে লিখে নি
Due to non-continuation of the and left. Yes. Para 2 you have they have stated.
Paragraph 2, Lordship.
Right.
Paragraph 2,
You give a copy of this to them.
Lordship.
স্যার আমাদের আপনার নিয়ে করেন আপনার কপি থেকে পড়ে যে রাখতে পারেন ছবি তুলে নেবো
So we are closing arguments then. Otherwise it's concluded. Quickly, Mr. Dhar. Don't have time.
difficulties Mr. Mojumdar has requested me to place one judgment. Malana, I have given them a notice.
Place it.
This is on doctrine of proportionality of
Yes.
punishment vis-a-vis judicial review, para 14. Malana, I have served the copy of this judgment to Mr. Bose. And the other judgment which Mr. Bose was telling that Kaushik Mojumdar, where the court, one of the court was relied by saying that this act is applicable. So dispute comes under 2K of that Commission Act, and hence writ petition is maintainable. Well, that submission was turned down by the Honorable Division Bench, holding that this is a purely contractual relationship between
Any
employer
particular
and employee.
this was cited by you on.
Yes, previously.
Oh, acha.
Yes.
Which paragraph?
Kindly come to straight away to para.
Other judgments have been extensively quoted.
Yes.
Narayana has also been.
No, kindly straight away come to page 15. It is further held that so far as the service-related disputes are concerned between a private unaided educational institution and its teachers or employees does not involve a public duty or public element and therefore is outside the purview of the scope. The appellant tried to impress upon the division bench that since it is coming under the Act, Commission Act, and then 2K, kindly come to page 3 once. 2I was referred. 2I mean school as recognized by the state, but does not include the government school.
St. Mary's and all these were, St. Mary's and Narayana all were
Yes,
considered.
all.
Yes.
The other judgment on 2023, volume 11, SCC 159, para 14.
Yes, what do you say on this? Ram Kumar has been quoted.
My lord, as regards my learned senior's submission on Kaushik Majumdar, Kaushik Majumdar dealt with an act which had set up a commission for resolution of school disputes arising out of employer-employee relationships in schools. Those disputes could be brought before the commission. But
Commission is existent.
a commission was set up under an act. Now, but the Anglo-Indian Code of 1993, my lord, was not considered. That was what we were trying to state. Also, my lord, the decision of St. Mary's.
1 second.
Yes.
এটা নিয়ে নেবে, ওরা ফটো তুলে নিচ্ছে, আমাদের কপি দেয়নি।
তোমার কপিতে রেখে দিতাম, আমি ফটো তুলে নিতাম।
Yes, St. Mary's.
My lord, in the decision of St. Mary's, my lord, subject to correction by my learned senior friend, my lord, that judgment does not consider a previous 3-judge bench decision of the Supreme Court in Jigya Yadav's case.
Which you have cited.
Yes, it is there in the compilation. My lord, yesterday, in Jigya Yadav's case, my lord, the argument, the proposition laid down was that the CBSE bylaws, they were law under Article 13. Therefore, any contravention thereof would entitle a person to maintain a writ petition. But in
So you have to
St.
file
Mary's-
a, I mean, you could just give a list of the judgments which you rely on. Mr. Bose relied on particularly 2 or 3 judgments
Yes.
and also this. So give a list on which judgments you're relying on. Give that list during the course of the day.
Yes, I shall give it.
Just have it typed and give us 2 copies and indicate which are the judgments which you're relying on.
And in St. Mary's, my lord, it was held by the Supreme Court that CBSE bylaws are not law within Article 13. But
We'll ask you to, we'll request to, both parties to file a brief written notes of arguments. You put in
My
your
lord.
arguments in there.
That in response to his argument, there is a paragraph 10, there is a material suppression of fact with regard to the pendency of the criminal litigation, what he has, my learned senior friend. This has no applicability, that it does not lend any meaningful assistance to decide that is for the simple reason. Here, the factual matrix is different and there is a full-fledged inquiry. Here, the inquiry did not commence in pursuance of the rule which I relied on. So this point was never argued in
So
this.
put it in your written notes. We are request you to file a written notes of arguments, both of you.
By tomorrow.
By tomorrow you can file it. You can file it, you have no objection.
They filed it before the other coordinate bench.
Actually,
It
yes.
has to be a very brief written notes of sir.
তুমি তো কালকে বললে ভাই নেই আমার।
Bullet points.
ফাইলটা করা
We will do it on Monday.
কালকে তো জিজ্ঞেস করলো রিটেন নোটসটা তোমরা তো দুজনেই
In view of certain new judgments having been cited by the appellant, and opportunities given to the respondents to meet the same, FUSAP heard learned counsel for both the parties on the said judgments. FUSAP learned counsel for the parties are requested to file the brief written notes of arguments indicating the judgments which they want to rely on. We're keeping it after a week then?
after a week. Instruction জমা দিচ্ছে।
on August 19, 2026, when the matter shall next be listed under the heading to be mentioned. Full stop. The written instructions filed by the private respondent in terms of our previous direction today be kept on record. Full stop. A copy of the same be handed over to the learned advocate for the appellant during the course of the day.
Deeply. My lord, may I have the
তিনটে থেকে দুটো থেকে তিনটে পর্যন্ত তিনটে থেকে
এতবার করে আর জাজমেন্টটা
বাকি স্পেশাল একটা 10% একসাথে দিচ্ছি দাদা দেখে নেবো
my lord, may I have
Yes, Mr. Basu.
may I have the privilege to have a cursory glance when this compilation is concerned, because I have relied on 3 judgments
Very
in
এই compilation ওটা
compilation যেটা আমরা দিচ্ছি এটা তুমি করে দাও।
yes.
My lord, item 3, my lord, under most compelling circumstances, I will be seeking an accommodation only for 2 days. Why, my lord? My lord, now Justice Banerjee was appearing in this matter. My lord, kindly he takes your lordship's last order. My
So
lord
this
has-
pertains to that, my lord, ashram matter, my lord.
Why is it appearance to be mentioned, Mr.
Yes, my lord, only names with respect to, my lord, the auditors to be appointed were to be supplied to your lordship.
No,
My lord, we have got 2 names.
What
and
would
we
Justice Banerjee have to
understand-
do with it? when
Yes,
he
sir.
was-
Difficulty is this, my lord. Today I have been briefed. Only thing is, my lord, we could not get the consent of the auditors. My lord, may I just have a word with the auditors? Kindly takes it on Monday to be
I
mentioned.
have, my lord, already obtained. my
You
lord.
exchange those if you can agree on the auditor, then no difficulty. You just take a
Let me take your
I was suggesting, my lord, because there is, my lord, some adversarial, my lord, situation.
both can be
That's why, my lord, one from this side,
Both,
one from
both,
that
very well.
side, my lord,
We'll
that could
consider
be
that. We'll
made.
consider.
In my
On
suggestion,
the
my lord,
prayer of the
subject to-
appellants, comma, in order to furnish the names of suggested auditors by the appellants, comma, the matter is adjourned till August 17, 2026, when it will be listed under the same heading. Full stop. In the meantime, comma, the parties may consider having a consensus regarding the names of the auditors.
Lord,
You can
will
also
find
agree
the
to
names on the
the
next
name,
occasion.
one from each side also you can agree.
Lord, on the next occasion, I shall find.
Next.
Great.
আমি একটা দিয়ে দেবো, তুমি একটা দিয়ে দেবো।
Yeah, that's best.
এই নামগুলো কি
Oh,
The matter which your lordship heard on
oh,
Friday.
yes, yes. Since the
Just, I think 5 minutes was left, and somehow, my lord,
Luck,
your
luck,
lordship
luck.
felt
This-
that Mr. Thakkar,
sometimes good things become counterproductive because it was partnered just to facilitate the
yes, facilitate the early disposal.
no, we'll have a separate date for that. I had a talk with the honorable acting chief justice, but whenever we can make an arrangement, that bench will sit for a day, probably a week or something.
But not, we can't expect this Friday, my lord,
No,
because again, my lord, what will happen in trial court?
we understand, Mr. Sen, but it depends on the acting chief justice. I've had a talk with him. It's before him. Heard since the matter was heard by a different bench, heard in part by a different bench, comma, let the same be listed before the same bench. ওই পাঠার জাস্টিস ভট্টাচার্যের সঙ্গে লিস্টেড করে
Obliged.
Item number 6, I appear for the appellate, my lord. In this
For the
matter, my lord, the respondent has filed an application being Can 3 of 2026 for repair. My lord, 3 things I have to submit, my lord. The affidavit page is missing, my lord, which is required, my lord, first. That is, fill up করে দিন, নাহলে আমি বলতে পারবো না কবে আপনি ইয়ে করেছেন। It was only handed over yesterday, my lord.
No, serve a complete copy, not like this.
My lord, 2 more prayers, my lord, I have
Yes.
from the
Got the
petition-
annexures. The annexures. are-
Annexure আছে, হ্যাঁ,
Only just the affidavit page is missing.
My lord, my lord, from the petition, I could find that the respondent number 2 has passed away in Jharkhand. My lord, no details. My lord, we were not aware that this person has passed away. But my lord, no details has been given to us, my lord. I will pray that let the details be provided, and we'll like to give an opposition to this scan 3 of 2026, my
No,
lord.
one thing, Triveni Singh, his heirs are already on record.
That I
Yes,
don't
Your
know.
Lordship. Only the hairs are on record. It's not on no, it's not on record, Your Lordship.
Then they have
I have
it has to be substituted.
Yes, Your Lordship. I have submit the death certificate of the respondent number 2.
Details.
You have to furnish the details of the heirs.
I will furnish the Lordship.
Learned,
And page number 6, Your Lordship, kindly see the house is in a very dilapidated condition.
Yes, but in the name of dead person, we can't.
Yes,
Deceased person.
Lordship, that is
My lord,
an
4
only-
weeks
I
time.
just want
Can
my
3 of
portion to be repaired.
2026
I
is
just
an
want
application for repair filed by the respondents. Full stop. From the application, it is evident that respondent 2 has died in the meantime. Full stop. Learned counsel for the appellants rightly points out that no order can be passed in the name of a deceased person. Full stop. Accordingly, the learned advocate on record for the respondents shall furnish the particulars of the heirs and legal representatives left by the deceased respondent number 2 to the learned advocate on record for the appellants by tomorrow.
yes,
By tomorrow. Full stop. Next para. The appellants will be at liberty to file an appropriate application for substitution. Full stop. Next para. The appellants shall file affidavit in opposition to can 3 of 2026 within a fortnight from date.
It will like 4 weeks, my lord, because my lord,
Repair application is urgent. File this substitution also in the meantime.
my lord, we have to
Within
can
a
3
fortnight
weeks,
from
my
date,
lord?
full stop, reply if any shall be filed within 1 week thereafter. Full stop. The matter shall next be listed on September 14, 2026.
much of Your Lordship.
What was the yes? The since it is pointed out that the affidavit page of the application has not been served on the appellants, full stop, the learned advocate on record for the respondent shall furnish such copy, comma, complete in all respects, comma, to the learned advocate for
Your
the
Lordship,
appellants in the
only just
meantime.
one innocuous pair. Kindly serve me the FAT copy, Your Lordship. I didn't get the
No,
FAT.
you're not entitled to that. Yes.
Deploy.
Yes.
Even my lord, I am for the
I am on behalf of the
Respondent-
applicant opposite party.
1 and 2, my lord. Partition should, my lord,
Respondent's Vakalatnama is not there in the.
my lord, in the I filed caveat, my lord. In the order.
Your Vakalatnama cannot be
Complete,
traced
my
out.
lord. Your Lordship, kindly see the.
Mr. Gupta, your Vakalatnama is not traced out. Vakalatnama.
Well, I am for the appellant.
Your Vakalatnama then
Yes, my lord.
can't be traced out.
I have
Without that, how can you maintain this application?
already in the order at
Your
the
Lordship,
time of
see the
admission,
order
my lord.
passed by justice.
Your Vakalatnama cannot be traced out. We'll have to proceed ex parte in your absence and we cannot entertain your application.
My lord,
File a fresh Vakalatnama, we're granting you liberty.
chance to face.
Only after that we can take up the matter.
My lord, paper book is ready. If your lordship, my lord, fix the date for.
Probably it doesn't register in your mind what we are saying. Without the Vakalatnama, you are not entitled to appear. So if you want, we can dismiss your application on that ground and take up the appeal then.
Give me a chance to.
If you want that, we can do that.
Give me a chance to file fresh.
From the office report, it transpires that no Vakalatnama on behalf of the respondents could be traced out. Full stop. The learned
1 and
advocate
2, my lord, 1 and 2. There are-
respondents could be traced out. Full stop. Next para. Accordingly, the learned advocate who intends to appear for the respondent numbers 1 and 2 shall file a fresh Vakalatnama at the earliest. Full stop. Next para. The office shall furnish a revised report in that regard. Full stop. The matter be listed next on August 24, 2026.
Date one.
My lord.
Mr. Gupta, you have got a copy of this application?
My lord.
Application copy you have got. Their application.
My lord. My lord.
Next. Yes.
My lord, this is my modification application of the judgment dated, my lord.
Have you
21st
served the
July.
copy on the other side?
Yes, my lord, we have served and I am filing my.
What is the modification you seek? Modification in a final dispose of matter. What is the
Lord,
modification?
we have missed to indicate the.
Oh, modification has to be done by the advance. Affidavit of service filed to be kept on record. Full stop. Let the matter be listed before the bench which passed the judgment dated July 21, 2026, comma, of which modification has been sought by the instant application. Next.
I'm great. Thanks.
Lordship, in this matter, I am for the lordship applicant petitioner. Suit for partition, lordship.
সবসময় এরকম চলে গেছে carry করতে।
Suit for partition, lordship, we are the defendant.
Mr. Shanal, in the full court, we noticed that you are wearing a normal jacket. Never do that. You are a practitioner of this court. Why?
I am apologies because sudden notice the
We,
court.
all of us noticed it, and it was surprising. You're so senior in the bar. You cannot do that. Then don't attend your seniors this oath. Don't attend. If you can't maintain the decorum, you're a practicing advocate. We were rather surprised and you were sitting. Then you should not have sat in the advocate seat. This is not expected from you. Yes.
Suit for partition, lordship, I am the defendant, lordship. I filed a counter claim. The suit was, lordship, decreed in favor of the plaintiff, lordship.
Yes.
But no share was declared and the counter claim was rejected, lordship, without assigning any reason.
Decree means partition suit, you said.
Partition suit, lordship.
Preliminary degree was granted.
Preliminary decree was the counter claim against lordship counter claim. There is one appeal. It is lordship 378 lordship. So your lordship earlier occasion directed to both the appeal to be heard together. Section 5 was allowed in connection with lordship the appeal FAT 432 and lordship now the injunction application.
What is the number?
FAT 432 lordship 20.
Can number?
Can number lordship can
2
lordship.
3 has been allowed. Can 3 is for recording death?
Yes, sir, is allowed.
That has been. Anybody is appealing for the other side?
No, see, last occasion section 5, during section 5 twice lordship service was affected but no one appeared.
This has not been directed to be served.
No, lordship. It was after allowing the.
So what sort of injunction do you want?
The status quo, lordship.
Did you enjoy an injunction in the trial court?
No, lordship, I was the defendant. Status quo was there during the pendency of the suit. It was lordship one Satish Chandra De who was the lordship who has lordship 2 wives. We are claiming through the first wife lordship Panubala.
Injunction is from drawing up the final decree.
Restraining from the final decree, and there is also threat of disposition.
No, where is that? Can we don't find anything of that sort. Nothing. No averment.
Only from drawing up the final decree.
There has to be an averment at least.
But averment.
At least an eyewash has to be there.
No.
Of our own, we can't unless there is a prayer. We cannot even mold the relief. There is no averment regarding injunction. File a proper application. We have already directed the trial court to proceed. The usual order has been passed.
Yes. No,
have we passed?
only section 5 has been allowed.
Oh, then we are the usual direction we are passing. This application we are in the interregnum. This we are passing necessary orders. If you want an injunction, proper injunction, file an application. This we are directing to serve copy.
Yes.
We are not recording anything on that.
I will file a separate application. Lordship,
do that when you take do that. We'll take it up. The present application is for injunction restraining the opposite parties from taking steps for drawing a final decree. Full stop. Next para. It may be noted that the present appeal has been preferred against the preliminary decree of partition. Full stop. The learned trial judge shall continue with the final decree proceedings, but shall not draw up a final decree subject without the leave of this court during pendency of Can 2 of 2023. 2023. Full stop. Next para. The appellates shall serve copies of Can 2 of 2023 on the respondents, indicating that the application shall next be listed for hearing in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellants. You file that application, mention it.
Directed to file the prepare the paperwork or
that direction was not there.
Not there.
Taliban and all, no, not there.
No.
The appellants shall put in postal costs and requisites for service of notice on the respondents, notice of the appeal on the respondents, comma, within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a fortnight. The trial court shall be entitled to retain as skeletal records for the purpose of continuing in the final degree proceedings. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Thank you.
Item number 10.
May it please the Lordship beg to appear for the appellants.
Yes. Yes.
This is our application for calling for the records of the lower court and the trial court for appropriate directions for passing.
This appeal is against what? Appeal is against what?
Appeal is against a decree, your lordship. Original decree, your lordship.
A
Wherein
suit for?
in a suit for eviction.
Eviction of a trespass.
Eviction.
Eviction of the tenant.
Trespass. Tenant by trespass.
You are the plaintiffs, actually.
We are the plaintiffs.
That's right.
We are the
You are
Shevayites of
appeal-
a devil. We are the
You
Shevayites.
lodged a caveat, you want to expedite the matter. You lodged a caveat.
What is the can about an application?
Can is for early hearing. File informal paperwork. No. You give a copy of the application to him, you are disposing of the application. But why did you lodge a caveat? Generally, defendants in eviction suits. Anyway,
Let a copy দিয়ে দিই।
it's your choice.
এটা original তোমার। এটা OC
Only one defendant responded.
only one.
Very. In view of the innocuous nature of the prayer, prior service of copy is dispensed with. Full stop. However, comma, since the caveator is represented through a learned advocate, the petitioner shall serve a copy of the application to the said learned advocate during the course of the day. Full stop. Can 1 of 2026 is disposed of by directing the trial court records to be brought by special messenger at the cost of the appellants, comma, to be deposited within a fortnight from date. Stop. Next para. In view of the appearance of the respondent through his learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. Full stop. The appellant shall prepare and file the requisite number of paperbooks within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Okay.
Certified vector appear for the appellant of item 11, your lord. On the last occasion, your lordship had admitted the appeal and there was a direction for affidavits. However, no affidavits has been.
What is the appeal against?
The appeal is against an order dated 18th August, your lordship.
What was done?
Administrator pendant letter was
Appointed.
Appointed, your lordship.
Appointed or refused?
It was appointed. In any event, your lordship, I was informed late last night by the learned junior advocate appearing for the respondents, opposite parties.
Yes.
That the arguing counsel has suffered a terrible medical ailment. So
Their counsel.
Their counsel.
Very fair on your part. Thank you.
Your lordship.
We appreciate
He
it.
had to be hospitalized. So
When should you keep it? Tell us.
They requested, I mean, your lordship, anytime.
What did they request? Tell us.
They requested in September.
That will be too much.
No opposition has.
At the very, we will keep it in the monthly list of, in our court, monthly list and daily list are same because we take up. So we'll keep it in the monthly list of September. Learned counsel appearing for the appellants, comma, in his usual fairness, comma, submits that he was informed that the learned counsel for the respondents has suffered accident or what?
Lordship,
Suffered an ailment. Full stop. Next para. Accordingly, we adjourn the matter and direct it to be listed next in the monthly list of September 2026. Full stop. The fairness of learned counsel appearing. What is your name, please?
Kaushal Roy.
The fairness of learned counsel, Mr. Kaushal Roy, is appreciated. Thank you.
So very grateful to you.
Yes. Yes.
Lordship, against the order of injunction till the disposal of the suit, the defendant before your lordship.
Disposal means granted.
Injunction granted. Now, lordship, there was a direction for mediation failed.
So affidavits were not exchanged at that point.
Affidavits already exchanged.
Exchanged.
Now, lordship, we mentioned this matter upon notice to the lordship plaintiff respondent. Yesterday, my learned friend also intimated that tomorrow through mail we have intimated.
Mr. Mukherjee, as you understand this matter, in this matter, disposing of the injunction will tantamount to disposing of the appeal itself. we'll direct one last notice to be given to them. We'll keep it tomorrow. Today, we'll keep it on Monday under the same heading application. If they don't appear, then we'll dispose it of ex parte. And we'll indicate in our today's order that we'll take up the appeal along with the application. In all the relevant papers, injunction, application, plaint, opposition are annexed here. At the time of call, none appears for the respondent. So we are informed that notice of mentioning was also given to the said learned advocate. So next para. As such, we request the learned advocate for the appellants to give a further notice to his counterpart appearing for the respondent, indicating that the appeal and the application will be taken up for hearing together on August 17, 2026, when the matter shall be listed under the same heading. Let such notice be deemed to be a notice of hearing of the appeal as well. Along with such notice, a server copy of this order shall also be served on the learned advocate for the respondent. Wait for the server copy. When it is put on the server, serve it along with the notice. Thank you.
Item number 30.
Yes. Yes. How are you? Yes.
Appeal arises out of the rejection of plaint.
Rejection of plaint.
The trial
Your
court-
plaint has been rejected.
Rejected.
On what ground?
The trial court has
You're
held
for the
that-
other side.
Your Lordship, I've been instructed to appear. We have not been served with any papers or copies. We are not on caveat. Your
There is
Lordship.
no caveat.
Even then, if they're appearing, give a copy and we'll hear them also.
I will serve copy of it.
Please serve and come back on. You seek an injunction.
Yes, I have seen.
What sort of injunction?
Injunction not to create any disturbance to my business and position.
Show us some prima facie case
Yes,
for us to grant injunction.
Now kindly look to the.
We'll grant a limited injunction then and ask them to serve a copy.
So I am the lessee in the suit property, 99 years lease. Suit property comes with a shop room wherein I am carrying on business.
Suit for?
Suit for declaration and permanent injunction.
Declaration of a tenancy right.
Lease right. Lease all right. Because during the pendency of the lease, my lord.
Yes.
See, the owner sold the property to the respondent number 1.
All right.
And after acquiring property, and this respondent number 1 is trying to create trouble to my business, saying, vacate, I will take positions. So my business is getting hampered. This is shop room wherein I am carrying on business. So now this is the injunction of not to create any disturbance to my position and business.
No, why was it rejected, the plaint?
Plaint that there is no cause of action. Only the trial court has held. I have annexed it. My lord, kindly come to running page 15, last paragraph. Findings of the trial court. From the meaningful reading of the plaint, it is manifest that plaintiff has been claiming his right title interest over suit premises under the grab of the lease. But being an alleged lessee, plaintiff has no accrued title or ownership over the suit premises, even if the lease is in perpetuity, in accordance with the statutory interpretation under section 105 of the TP Act. Moreover, the cause of action is pleaded in paragraph 10 of the plaint, arising from the alleged deed of sale dated dato, is illusory since under the guise of that cause of action.
No, they have an arguable case.
Yes.
You have an arguable case, but we may dispose of the appeal as well as the application on the next date. Give a copy of the memo as well as the application.
My lord, I understand.
We'll grant a limited injunction. What is the injunction you are asking?
Injunction praying for.
Your Lordship, we are not creating any issues with the lease. Lessee, they had asked for cancellation of our sale deed. That was one of the primary reasons why the suit has been rejected.
That probably would be a bit beyond their scope of the
Yes,
suit.
Your Lordship.
But partial rejection
Your
can.
Lordship, I just pray that Your Lordship may keep it next week.
We are keeping it next week. We're asking you to serve a copy of the injunction as well as a memo. You come prepared on the appeal as well.
Yes, Your Lordship. Till then, Your Lordship will kindly not grant any order of
No,
stay.
no. You cannot disturb their position.
We are not disturbing their position.
Do you undertake to do that? Have you instruction of your client?
Today, my wakalatnama is not there, Your Lordship.
Then
Therefore,
no
my
question.
taking-
You'll have to grant injunction. Since the prima facie case has been made out for hearing of the appeal on merits, the respondents are restrained by an order of injunction from disturbing the peaceful possession and enjoyment of the appellant stroke petitioner in respect of the suit property till September 30, 2026 or until till September 15, 2026 or until further order, whichever is earlier. Full of the matter be listed next on August 24, 2026 under the same heading. Full in the meantime, the appellant shall serve copies of the memorandum of the appeal as well as the application for injunction on the learned advocate having instruction to appear for the respondents and file a receipt in that regard on the returnable date. Full stop. How soon can you file your vakalatnama?
Within a week, Your Lordship.
On the prayer of learned counsel having instruction to appear for the respondents, leave is granted to the said learned advocate to file her vakalatnama during the course of this week.
Much obliged.
Thank you. We make it clear that in view of the short ambit of the appeal itself may be taken up for hearing along with the application on the returnability.
Much obliged.
Also, the user indication. Quality of project situation.
My appeal and my
cancellation সেটা যেতে পারবো বাকিটা পারে কিনা সেটা না হয় রিমান্ড করে সেটা yes sorry
because it is my appeal and my application,
right?
Because the only thing is that there is a previous order
You
passed.
claim ownership of the property also as well as the appeal and the application. What is the suit for?
Suit under section 2G.
Great.
But there is a case, I believe.
For a change, Mr. Bhattacharya is on a better side. Yes, generally he champions the cause of 2G cases.
But the thing is that there is an order passed by your lordship that there is a deficit court fee. I have to check that. Because
that's the best order you can get, probably.
Deficit court fees has been paid previously.
You have paid it, yes. No, that notice is there. Should এখনো defective দেখাচ্ছে নাকি? No, it's no longer being shown as defective. Deficit court fees you put in.
Okay.
There are further deficit court fees. No.
There is a previous order passed by lordship in May, probably, that there is.
Let us check.
There is a deficit. March, your lordship has indicated there is a deficit court fee. A deficit court fees has been put in after that, and there in May, there is a order passed by your lordship that deficit court fees.
On 20th of May, you put in the deficit court fees.
Yes.
So very well, now it's fine. You move the application. What is your prima facie case? Just because it's the first appeal and there is no admission hearing does not mean that you will get us.
The plaint itself. Page 11 of the application.
Yes.
Kindly see. Paragraph 1, they have said that one Madhuri Jaswal, he was the original tenant. Paragraph 2, they have said died and after demise tenancy has been held by her, has been extinguished under the provision of section 2G. And thereafter that the plaintiff on several occasions had requested the defendant to hand over the possession in respect of the suit premises, but the defendant refused to comply with the said request made by the plaintiffs. And what's
the wrong in this?
Yes, my lord.
After her demise may not be immediately after that.
Yes.
What are you?
I am the spouse.
So you are not a dependent of Madhuri Jaswal who was residing with her.
That they have to allege that they have to allege that I am not the dependent.
You have to show.
They have to first allege that I am not the dependent. Thereafter, in written statement, I can deal with that. If they have not alleged in the plaint, I will not
that
be
would
able
have been
to.
a threshold ground. But after the suit is heard, evidence is laid, that cannot be.
In evidence also, they have to show that I am not the dependent.
Negative proof cannot be given. You have to show what is your locus standi there.
I am the spouse.
Admittedly spouse.
I am the spouse and I am living with her till her death.
That does not entirely. You have to show that you are a dependent. By 2G, automatically, by default, only people who are dependents and residing with her at that time, you were residing with her at that time,
yes,
you agree. Prima facie, we agree, definitely. You are her husband, there is no allegation of strained relation, obviously.
Yes,
but you have to show it's your burden. After the question of onus and burden gets academic, after the hearing of the suit.
And what was the learned
what proof did you adduce regarding that you did not have any income? Did you adduce any oral evidence to say that you have?
Oral evidence are there.
How can they prove your special knowledge?
And the second thing is that the trial court proceeded on the footing that I have not resided with her at the time of death.
Even otherwise, you had to show.
There is no findings of the trial court that I am not the dependent. The findings of the trial court is only with regard to that I was not residing with her at the time of her death.
Let us see the judgment once come to it.
The judgment is also annexed with the copy of the judgment and order is annexed with the
memorandum. We are calling for them. Note to that. Everything in your wife's name.
Yes, my lord.
So did you show any document of possession? Something?
Yes, my
You
lord.
understand you are in
Yes,
her
my
court.
lord, I have, my lord,
Which
my lord, exhibited. My lord,
Which exhibit?
My lord, electricity bill and the Aadhaar card. I have
Pardon? Pardon?
electricity bill and Aadhaar card.
Aadhaar card you have produced.
Yes, no. Exhibit.
So those were not considered?
No, my lords. If your lordship kindly comes to, my lord, the internal page 19 of the judgment, that is the findings of the trial court.
Yes.
My lords, if your lordship kindly sees, my lords, in the middle portion, I do not find any averment of the plaintiff.
Yes.
That the dependent happens to be the husband of the plaintiff. The written statement filed by the dependent speaks of the fact that dependent happens to be the spouse of Madhuri Jaiswal, but now in the written statement it is directly mentioned that with the clarity that the said dependent at any point of time till the death of the Madhuri Jaiswal resided with her in the tenanted premises. That is there in the
But
written
they have alleged in their evidence that you did not reside with her.
Malas, if they have said that, Malas, first of all, they have send me a notice. Malas,
They send you a notice.
Immediately after the death, they have filed the suit. Adding,
No, 2G renders you a trespasser. You are not entitled to a notice. They can file a suit
yes,
directly. You contested the suit also.
obviously, there is no
Obvious
notice
section
required.
6
No notice is required.
Exactly.
But they have filed the suit. They have not alleged in the plaint. Your lordship will not find that I have after the death of the
specific evidence is PW1 that Madhuri Jaiswal resided with her daughter and you did not reside with her. So you say to dispel this, you had produced certain documents.
Yes, my lord.
What are the exhibits? Let us see the exhibit list as reflected in the judgment.
Yes, my lord, but has not been
Must have been marked as an exhibit.
In the judgment, my lord, has not been specifically stated what are the exhibits. Only the exhibit number has been stated. Internal page 5.
Formulation is not 92. If both the parties knew.
Internal page 5, my lords. Only the exhibit
Yes,
number has been stated.
1 to 3B. So which were the Aadhaar card and the Aadhaar card you said and
The
electricity
Aadhaar card
bill
and electricity bill.
in your name.
Yes, my lord.
Well, let us assume that you were residing with her. What about your being dependent on her? If you assume that you resided as husband, then you also have to assume that we cannot assume that you did not have your own income. You have to show something, some evidence. Even after that, after the lapse of 5 years, probably.
No, my lords. The tenant died in 2019. My lords, they filed the suit in 2021.
No, not by then, I mean, during pendency of the suit, you have.
The 5 years elapsed.
Now you have been rendered a trespasser in any event.
My lords, spouse, life estate.
देखिए একটা transition is
Spouse.
Even then, 5 years has elapsed.
Spouse is life estate.
Right. Only dependent remains. What about that?
Dependence, I have to find from the evidence.
Yes, Mr. Bhattacharya, there is no evidence in I mean either way that he was not dependent. That component is not considered at all.
What is the premise of our suit? Our premise of our suit
2G.
is no, not Millard on the ground of 2G. It is eviction of a trespasser, but not in the. We are not even acknowledging him as a husband. Kindly see the plaintiff.
Paragraph 2, my lords.
Paragraph 2. Kindly see that one Madhuri Jaiswal was the recorded tenant in respect of such and such.
How do you explain his presence in the property then? Yeah, the entry point had to be pleaded.
Direct trespasser.
The entry point is not nothing is pleaded. All on a sudden, then it starts. Starts.
Madhuri Jaiswal died, and after
Madhuri
her
died.
the demise of the
Extinguished.
extinguished.
Then the plaintiff on several occasions had requested the defendant. You do not give a single line, devote a single line to say when he entered.
Very well. Then
Your ground is 2G. You have not explained how he entered into the property then.
that
He's a third party, then you have to devote a sentence to at least that he was. When did he enter the property? And
Millard, let us take it as case Millard as failed from your lordship as Millard expiry of 2G, 5 years. Millard, let us take. Still also Millard, Millard, that case is Millard, he cannot substantiate. Kindly comes Millard, page 16 of the stay application, the written statement. Now kindly see Millard, page 20.
I hope you are not showing the affidavit.
Yes. Yes, Millard, kindly see occupation.
We are guessing that.
Occupation business, therefore not dependent.
Don't be so violent on the 10.
Very well. One.
A bit
Number
sober.
2, Millard.
Bit mellow. Yes.
Millard,
Yes.
there are 3 conditions, Millard, in 2G, not 2. One is residing, ordinarily residing with him at the point at the Millard time of death. Number 2 is
Yes,
Millard
what we said.
dependent upon him. And number 3,
The
Millard,
occupation, he has got the taste of jugular.
kindly see
He's going
Millard,
for
the
it.
third Millard point. That is the proviso to Millard 2G.
You enjoy while you are appearing for the plaintiff in an exceptional case.
I do not get that chance, Millard. This is the exceptional.
Generally, you are accustomed to losing cases because you are happy for the 2G turn. We appreciate that, Mr. Patrick. We are happy for you. Limited happiness for this matter.
I will check the defense. I check the evidence. I'll check the evidence.
Page 20, he's page 20.
Even then,
By occupation business, I was saying.
even then, the income has to. Even if I reside with her.
3 things. One is that we are assuming that assuming that you are her husband, you resided with her. We are proceeding on that premise because we find you are rightly pointing out that those exhibits were not considered. We are taking it on face value. What you are submitting, that one was an Aadhaar card, and you must have had instructions and you must have gone through. But still, 2 things go against you. One is that 5 years has elapsed, and for this, like under section 6, there is no compulsion that the notice has to be a precondition or something like that. Trespasser suit is sufficient. During pendency of the suit, in any event 2G would have expired. 1. Secondly, that if you in your affidavit you boldly say you are doing business and you don't adduce one line of evidence to say that you are a dependent on her, how do we, even consider your case under the exception to 2G?
One thing is that,
5 years, yes, you are a spouse.
Yes.
So what about dependence?
Dependence only one thing. I will check the evidence. Firstly, they have to allege that when they are taking this grounds of section 2G, that I am not the dependent. Then I will get an opportunity in the
There
written
is no
statement to deal
statutory
with this.
requirement to plead that. No. They are entitled to file a suit if under 2G you are not covered by 2G. They can file a suit saying that you are a ranked trespasser. They need not plead the law. They need not plead these ingredients also, because unlike the previous specifically back section 16, where readiness and willingness were to be pleaded, which has also been amended. No pleading is necessary, only proof. So if the statute mandates some pleading, if that pleading is not there, you are absolutely right. Previously readiness and willingness. Lack of pleading would vitiate the suit. No pleading is required under the law. They are required to say that you are a trespasser, evidence is taken, and this is not a plain rejection case or inception case. This is not a threshold case. Both of you have adduced evidence. After that, judgment has been passed against you. Now you cannot say that they have not pleaded this, not pleaded that. Pleaded you are a trespasser, you have to show what is your status to the property.
And the trial court has also not deal with that, because the issue has not been put forward to the trial court. That is why
what it will record to prove? The issue is framed at page 4 or something.
The question of dependency. That is why that has not been argued properly before the trial court.
No. You did not know. Parties were aware what case was put to them. They have pleaded 2G. That's sufficient. They need not have pleaded 2G, the section also. See the issues at page 4 of the impugned judgment, internal page 4. 4 is sufficient. Option number 4 is sufficient.
Their admission is also.
Even 6 was redundant. Notice to quit is not necessary. Filing of an eviction suit against a trespasser is sufficient. 7 is very categorical on that, sir. 7 is very categorical. 4 read with 7.
That is,
give you ample opportunity to lead evidence. Have you got a copy of your evidence?
I have, that is why I have to check.
We will check.
One copy, that is.
Give it to us.
I am giving it.
We'll remember your overzealousness.
But one portion is marked, Millard, that is the relevant Millard cross-examination.
Which page?
Millard, that is with Millard Justice Day.
Millard.
That marked portion at the bottom, Millard, cross-examination.
Right. You've seen it. Your evidence.
Which portion?
You take this.
From the another.
No, you have another marked copy. You have another marked copy, then give that to us and give this to him.
Oh, yes.
Give the marked copy to me. Find out the marked portion, give it to me. You give it to him. The marked portion will show your learner friend.
Please see the evidence dated 7th of November 2024.
7th November 2020.
7th November 2020.
Cross-examination on behalf of the plaintiff. The very first line.
But
please see your cross-examination. With this cross-examination, you did not require the plaintiff.
Another thing, I kindly see Millard, the affidavit in chief of DW3 in that bunch. Millard, I do not know whether this it's there, Millard. Kindly see Millard, the DW3.
What does it say?
Millard,
Who is DW3?
DW3 daughter of the defendant.
What has she said?
Paragraph
Father
13,
did not live with us.
Paragraph 13, mother died, and on 9th, we have right to the tenancy till 19th August 2024.
She is the daughter.
Daughter admitting she has then
It's her right. She cannot concede his right on his will.
As of today, that has matured 2026.
Show him 7th of November cross-examination. Whatever benefit of doubt you could have had to see the cross-examination.
On the 7th of November, I have seen,
Read it for us.
He's perhaps indicating that it is a fact that I do business.
No,
and
please,
thereafter, yes,
please read that cross-examination.
yes,
Read from there.
I casted my last
No,
vote from
it is
premises
fact.
number.
Read from there.
Yes, it is a fact that I do business. Second, yes, I casted my last vote from premises number 9, Belicious Road, Howrah.
Belilius Road, which is not the suit property.
Yes, no.
Please continue.
It is a correct that except the Aadhaar card in all my documents, the address is given of 9 Belicious Road, Howrah. My son Sumit Jaswal is present in the court today. Yes, I do not exactly, but maybe.
Also say that she surrendered and all these things, so we are not overlooking that. But if you admit that your all the other documents apart from your Aadhaar card which you produced show that you live somewhere else.
But
preponderance of probability court accepted one version. And you do business, there is a question of dependence.
One thing is that in the suggestion they have put in, they have also not said I am not the dependent. Suggestion is the case forwarded by them.
Suggestion is not that you are the.
I am not the dependent upon the Madhuri Jaswal. Please just see these suggestions they have put in.
What suggestion? What suggestion? What are you saying?
The suggestions after the cross examination. Kindly see.
Need not. It was your onus and your first burden to show that you are dependent.
What suggestion will do? You have admitted
in your chief, have you stated that you are a dependent? Let us see your chief. Very good. Chief is also there in this bunch.
Yes. Previous.
Yes, it's there. First paragraph of business.
Yes. That's what I'm having.
Did you produce rent receipts in your name also?
Yes, Manoj. My name and the Manoj, the name of my son and daughter. Manoj, that is exhibited
After her demise?
after demise. That is also Manoj I have produced.
Page 14.
Which exhibits were those?
Let us check up. Corresponding marker, Y coming.
Yes, Mr. Bhattacharya, we should rent receipts in that.
That has also been dealt in the
Page
impugn
14.
judgment. They could not corroborate that.
Page 14.
No evidence?
Paragraph 14.
Page 14, judgment.
Page 14 of the judgment.
Boss, can you back the
Not you put kind enough to see, Mr.
Yes. Page 14.
Kindly see the lines on the middle, Millard. It starts.
I'm going through.
It is needless to mention.
Yes.
It is needless to mention the rent receiver produced from the end of the plaintiff
Oh,
being marked as exhibit to all issues in the name of Madhuri Jaiswal. The said rent receipt spanned a considerable period of time from 2013 to 2019. The rent receipt produced from the end of the defendant as alleged to be issued in his name as well as that of his son and daughter embrace the period of November and December 2018 and of January to September 2019, but it transfers from the rent receipt dated 31st May 2019 being produced by the plaintiff. It is Madhuri Jaiswal in whose name the receipt was issued and it covered the month of January, February, March and April of 2019. It is just difficult to digest and believe as to when the rent receipt has been paid from the month of January to April 2019. During that time, the tenancy was held by Madhuri Jaiswal. How come a second receipt of a later date reflect the time payment of the rent of the same period? The document gets the clouded and tainted by suspicion and falsity owing to the fact that the rent receipt dated 31st May 2019 or any rent receipt issued by the plaintiff in the name of Madhuri Jaiswal was never made the subject to challenge in the testimony of PW1 specifically during his cross-examination, and on the contrary, the defendant all along placed reliance on those rent receipts and ventilated them to substantiate the existence of a valid tenancy for marking it as a panacea of all problems attached.
No, but they produced rent receipts for a considerable period, November and December 2018, continuous from November 2018 to September 2019.
Millard,
How many rent receipts? How many rent receipts?
January to September, 9 months.
Individual rent receipts for all these months? At least more than one.
Collective.
Collective is there. P was collective, P or one of them.
But they placed Millard ultimate reliance is on Madhuri Jaiswal's rent receipt. 30th September
The question of
2019.
placing reliance, if they exhibited the documents, court had to look into
The
those.
court has Millard
It has looked into, but this is not a way to 1 to 3B only. So 3B may mean at best 1, 2, 3, 3A and 3B.
January to
5.
September.
And the 3A and 3B, at best 3 rent receipts were produced. A single entry seat.
You kindly see the months of August, September, October. Yes. Then my lord, next page, November and December. Then January to September.
Oh, that's why they have adduced evidence that she had surrendered and all these things. It was an independent case you made out that she had surrendered and no tenancy was given to you. He has not been able to establish surrender.
That's why, my lord, we did not say, my lord, Ashok Jaiswal, my lord, inherited by it. Although, my lord, this is a eviction on the ground of trespass. My lord, I also have one, my lord, alternative point also.
এখানে এটা আমাদেরটা দুটো নাম লিখতে পারছি 27 জিএফ টেস্টিমেন্সি ফিটিং এটা হচ্ছে চেক পেজ সাবমিট করবে তো একটা রেন্টিস একটা সিঙ্গেল হতে পারে সারেন্ডারটা তো ইম্পর্টেন্ট সাউন্ড পরেরটা সারেন্ডারটা তো আপনি ডকুমেন্ট
Yes, Mr. Bhattacharya, what is your next point? Other point? Other point?
Yes, other point, my lord, kindly see, my lord, lordship has, my lord, seen, my lord, our cross-examination to them, alternative residence of at Belilias Road, Howrah. My lord, that part of the cross-examination.
Yes, yes.
Now, kindly see, my lord, the proviso, my lord, appended to section 2G. First proviso.
If they have an alternative account.
Exactly. Then, my lord, 2G, my lord, doesn't apply at all. Kindly see the first proviso.
These were not considered by the trial court.
That is in appeal, my lord, a point of law. Evidences were before it, my lord is considering as first appeal.
Yes. Yes, you don't find any prime case.
No, sir. As further, my lord, they are saying residence, my lord.
প্রুফ লাগবে এরকম তো কোনো পার্টি কিছু বিষয়গুলো তো মনে হচ্ছে পজিটিভ কিছু সারেন্ডার সারেন্ডার করতে ইন্ডিপেন্ডেন্ট কর্পোরেটিভ করতে নিচ্ছে আর
Yes, what do you say?
Second proviso.
Yes, yes.
No, the second proviso, yes.
Second term, cover.
রেসিডেন্সের জায়গাটা কোথায়? First of all, Manoj, this is it provided that the time limit of 5 years
shall not apply to the spouse.
Spouse of the tenant, Manoj, spouse is enjoying, Manoj, life.
Who was ordinarily living with the tenant up to his death as a member of the family and was dependent on him, and who does not own or occupy any residential premises. So it's a conjunction.
First of all, Manoj, this section itself, Manoj, says, Manoj, the spouse will enjoy life estate. Now this proviso is saying that provided that the time limit of 5 years shall not apply to the spouse of the tenant who was ordinarily living with the tenant up to his death.
Universally, it is for 5 years, for all years.
Yes.
Exception is carved out proviso, in the proviso. Proviso says This time limit of 5 years shall not apply to the spouse who was ordinarily residing and does not have an alternative accommodation. If you read this in conjunction with G, G is universal for a period not exceeding 5 years from the date of death of such tenant, whichever is later. His spouse, son, daughter, who are ordinarily living, who are dependent and who do not own or occupy such and such, they are also do not own or occupy any residential premises. So that clause is universal in the embodied in the section as well as the proviso.
This one. Yes, just on this point, Manoj.
That is also the main section also covers spouses.
Yes,
provided he does not have any, she does not have any alternative accommodation. This carves an exception that will not apply at all if you don't have any alternative accommodation, being a spouse.
So on that point, Manoj, I want to come back. Only on this point.
We are refusing stay. We are keeping the appeal.
Manoj, kindly, Manoj, make it not today. I will address your lordship on the Manoj tomorrow.
Come.
Manoj,
Another point, Millard.
Yes, Manoj.
Millard, the next page of the Millard, the 7th November 2024 Millard deposition. The 3 paragraph from the bottom. Millard, it starts not a fact.
Not a fact?
Not a fact. I never resided at the suit premises. I did not file any document to show that I was residing in the suit premises during the lifetime of Madhuri Jaiswal. Stay should be Millard refused.
Manoj, I will show the exhibited document, Manoj. If it is exhibited document and Manoj, something has been stated, Manoj, thereafter, that will not be reliable.
Your Belilius property documents are admitted, everything is admitted.
Manoj, they have stated a stray question, that is why it has been answered like that.
If it's your document, and if you disprove that document in your own cross-examination, then how can you rely on that document? You are right, documentary evidence, if it is exhibited, it can't be, it has to, documentary evidence overrides oral evidence. But if the evidentiary value of the documentary evidence itself is at stake, then we have to look to your cross-examination, who is proving that you only proved the documents.
Yes, ma'am.
If those are marked as exhibits after you proved them, and if you disprove them in your cross-examination itself, then you have to look at that also.
First of all, Manoj,
look at the evidentiary value of those.
First, Manoj, I have stated in that, Manoj, I have stated that in my Manoj affidavit in chief. Second, Manoj, when the document was exhibited, Manoj, there is no
Purpose of
objection.
cross-examination is to demolish the chief. That is the
Manoj,
purpose of cross-examination.
and Manoj, secondly,
Admit in cross-examination
Three conditions, none of them he could prove, or rather you have admitted in
the contrary.
Manoj, one thing is that, Manoj, and the documents.
You have said you have alternative accommodation. Apart from Aadhaar card, which we only exhibited, all other documents stand at your Belilius address. You did not reside, you admit in your cross-examination, you did not reside with your wife throughout your lifetime.
The address is admitted. It is a residential premises. I was living.
I did not file any document to show that I was residing.
There are two things, Manoj, regarding the alternative address, Manoj. It is not, Manoj, coming from the cross-examination. That is the residential premises.
In view of the short ambit of the appeal, we intend to take it up for hearing along with the application. Push up, the learned advocate for the respondent, plaintiff respondent, is requested to furnish sufficient copies.
We are keeping it.
Of the this copy you are keeping. You have other copies.
Yes.
Sufficient copies of the evidence adduced by the parties.
Before Millard concluding, Millard, kindly
At the time of hearing, push up the appeal along with the application be posted for hearing under the same heading on August 17, 2026. Yes.
The last Millard, kindly see the death certificate of Madhuri Jaiswal. Yeah, it has been exhibited from my learned friends. Kindly see, Millard, the address.
What do you want to say?
Yes, address of Ashok Jaiswal is 9 Belilius Road, husband of the deceased. It was marked exhibit from their side.
Point out when you take it. You also take note of this.
Manoj.
Give a copy to them also. The entire thing, once you want to rely on, give it to them.
We have already given to them.
Yes.
You come prepared. Valiant effort. We honored that by keeping it on 17th. but we cannot do further. Yes, next. Thank you. Next.
Yes. For the appellant petitioner before.
Yes.
There's a caveat, my lord. I have sought copy on the injunction application upon them.
There was a caveat.
There's a caveat.
Fair.
Not appeal is out of the dismissal of my suit on contest. My lord, the plaintiff petitioner has appellant has filed a suit for declaration, cancellation of sale deed and injunction, making a specific case that fraud has been practiced upon her to obtain the sale deed without payment of any consideration amount.
Both sides are synonymous.
Both sides are synonymous. Names are same.
Acha.
Both sides are same. Names are same. You know, after framing an issues and taking evidence,
Declaration of your title.
declaration of title, and declaration that the sale deed procured by the respondent defendant is forced, and apart from that, there is no payment of consideration money.
Sale deed was executed allegedly by you.
By you, putting an LTI. Because I am an ignorant lady, I was taken to the registration office on the garb that after the demise of your husband, you are a poor person, so I am providing loan to several different ladies in the rural sectors for their upliftment in the economically. Then I was taken an assurance to the office for getting a financial loan. So I was obtained LTI on some papers by the design persons, and then obtained its sale deed executed. And after a few days, when
So that is your case that has been dismissed.
that has been dismissed. Now, now I have filed an application for injunction because now they are trying to dispose of the property.
What is your ground in the appeal? Just satisfy us.
My lord, in this matter, my lord, in injunction in the court below, my lord, they have not pressed their injunction application.
At that point of time, it was not necessary.
My lord,
Injunction is a continuing cause of action.
My
You can
lord-
press any time. If they have disclosed the current cause of action, let us see their approach.
my lord, property has been possessed by me, my lord.
That is why they are asking for injunction.
And in the
Injunction is regarding third party interest.
Third party interest. Because now they are trying to dispose of the property, they are showing the intending
Granted.
purchasers. So after the disposal of the suit, now they are become desperate to dispose of the property.
Cannot dispose of it.
My lord,
hear this on merit.
that's why, my lord, I have taken this information that they have not pressed.
We'll
their-
record that. We'll record that, but still grant injunction. We'll give the reasons. The present appeal arises against a judgment and decree whereby the suit filed by the plaintiff stroke appellant for declaration of title, cancellation of a sale deed purportedly executed by the appellant in favor of the respondent and for consequential relief was dismissed. Push up next para, learned counsel for the appellant submits that the respondent is now seeking to create third-party interest in respect of the subject property, taking advantage of the dismissal of the suit. Push up next para, learned counsel appearing for the caveator stroke respondent opposes such submission and argues that during pendency of the suit in the trial court, the appellant had initially filed an injunction application but subsequently not pressed the same, not pressed a double inverted mode, not pressed the same. Full stop, next para. However, upon perusal of the present application, we find a current and continuing cause of action having been made out. Full stop, in any event, the cause of action for injunction is continuing in nature, arising d die in diem, and as such, just because no injunction was required by the appellant during pendency of the suit does not necessarily preclude the appellant from seeking a similar relief on a subsequent and continuing cause of action in the present appeal. Full stop, next para. Even otherwise, since the first appeal involves adjudication of questions of both fact and law on merits, we find that a prima facie case has been made out for grant of injunction. Full stop, accordingly, can 1 of 2026 is allowed on contest, thereby restraining the respondent and or her men and agents from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property till disposal of the appeal. No orders to cost. In view of the appearance of the respondent through her learned advocate, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records and the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when it's ready for hearing. Yes. Yes.
My lord, suit is for partition. I am for the defendant number 1.
Preliminary degree or
Preliminary degree passed. My lord, it was. I have not challenged the preliminary degree. Therefore, my lord, I can't say anything. Only final degree. Otherwise, my lord, the preliminary degree I engaged an advocate who in earlier suit my advocate. But in the naturally I handed over the file to him. Subsequently, it has been found he is appearing for the plaintiffs. And some other advocates have been engaged by him to contest my case. At the last moment, written statement was filed and Order 12, Rule 6 application was filed by the plaintiff. Admission that the some portion has been given to club.
This is a judgment under Order 12, Rule 6.
Yes. So for preliminary degree, my lord, I have nothing, whatever it may be, but I have nothing to say. Final degree, my lord, if your lordships kindly come to the commissioner's map, then the decree, annexed with the decree.
Whatever you submitted, Mr. Mahato, you have taken as grounds in the this present appeal also.
Yes.
That handed over.
Yes.
Policy. Yes, map.
Map, my lord, kindly see the total land has been given.
Which is yours?
Mine is, my lord, D1. Below the yellow colored portion. Yellow colored portion.
You have been given OLT money?
Well,
OLT money has been given to you?
No. My lord, total person is, my lord, 5. 4 are plaintiffs. I am the defendant number 1.
So this is proportionate. A little less than proportionate, maybe.
So far area is concerned, I have nothing to say. But the
Location.
allotment, my lord, this area,
Location.
it is, my lord.
There's a road beside it.
My lord, it is, my lord, 22 by 140. My lord, if it is 22, the breadth, my lord, the mandatory open space 448.
Cannot make any constant.
It should be, my lord, square separate. And my lord, in the middle, there is a structure. Nothing has been given to me. Within yellow portion, at the middle, there is a structure.
That's why we saw that structure. We asked you whether there was any OLT money given to you.
No.
Correct. A prima facie case for hearing of the appeal on merits has been made out. Full stop. Accordingly, the respondents and or their men and agents shall remain restrained by an order of injunction from disturbing the possession. We are not passing. We don't know about the possession. We'll put a status quo regarding restraining the respondents and their men and agents from selling, transferring, alienating, and or changing the nature and character of the suit property till disposal of the application. Full stop. The parties shall maintain status quo in respect of their with regard to their respective possession in respect of the suit property, also till disposal of the application. The appellant shall serve copies of Can 1 of 2026 on the respondents, indicating that the application shall next be listed for hearing in the monthly list of September 2026, when an affidavit of service shall be filed by the appellant. Mr. Mahato, why is the secretary there of that club a party?
Well, he has been added as defendant number 2. Well, their plaintiff's P is my mother have gifted 1 katha of land in favor of the club.
So then you have to serve them.
Well, on my own, my lord, I serve the copies to all. Again, I am
if they appeared, we could have.
Yes. But so far the club is concerned, it has come back with refused. Whatever it may be, I shall serve again.
Better luck next time.
Yes, I shall serve again.
In fact, same luck next time. If this happens the next time, then luck. Yes.
I'm good.
Thank you. Yes, you are for the appellant.
I'm for the appellant, but
who are you searching for?
This is the suit for decree of nullity of marriage under section 12.
Wanting expeditious hearing only.
my lord.
You're wanting expeditious hearing?
Yes, expedition and call for the records expedition on my cost, and my lord, out of
Nullity suit has been dismissed.
not dismiss, my lord, decree on divorce under section 13 of the Marriage Act.
Your suit?
My suit.
You did not ask for that alternative relief?
No.
Not also as an alternative relief?
Not really, my lord, but kindly come to the last page of the judgment ordered. The marriage solemnized between the parties, such and such, as per Hindu rites and customs, such and such, is hereby
Sir,
dissolved by a decree of the under section 13.
Copy paste error maybe. No, ordering portion also says the same thing. তাই কি রে mental cruelty বলেছে anyway
Defective.
What is the defect?
My lord, I have not seen it, my lord.
We are there for you to see it. Why should you see?
Excuse me, my lord. This is my duty to see, my lord.
Just check up. Oh, classification of the appeal. What classification? Oh, it is stated memorandum appeal from the original order. From original decree, you know. Is a decree. In the memorandum, we have written in the caption from the original order. Really from original decree. Thou will not be there.
I'll leave to, my lord.
Leave is granted to the learned advocate on record for the appellant to rectify the caption of the memorandum of appeal to cure the defect as pointed out by the stamp reporter. First up, the appeal arises out of a decree whereby the learned trial judge, while deciding the appellant's suit for declaring the marriage between the parties a nullity, instead, granted divorce on the ground of cruelty, apparently making out a third case. Push up, since the prima facie case has been made out, the appeal is equal to be heard on merits. Push up, in view of the prayer made in Can 1 of 2026 being innocuous, we do not direct prior service of notice of the application on the respondent. Push up, Can 1 of 2026 is disposed of by directing the appellant to put in postal costs and due requisites for service of notice of the appeal on the respondent within a week from date. Full the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. Next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for hearing as and when the inclusion in the list as and when the same is ready for hearing. No rest to cost.
Get. Department.
But I appear for the appellant.
Mr. Kaur, you just pronounce the name of your client first. Mr. Kaur has to pronounce it.
Birchberry.
What is the second word? High rise.
Without a hyphen, it becomes very.
12, 21, and 30.
We'll forget. We'll write on a slip of paper.
Lord, I find, Lord, there were 17, Lord.
Who are not appearing, we have to ascertain that actually.
It's not, there was a previous direction, my lord's order, my lord, that to comply, my lord, service upon all respondents, as I understand.
Exactly what I was trying to point out, Lord. I find from the affidavit of service that, Lord, 17 respondents could not be served because of insufficiency of address. The problem is, Lord, these addresses are taken from the conveyance. This is a suit for, Lord, declaration, injunction, and for cancellation of certain conveyances which have been executed. Now, Lord, these addresses which are taken from the conveyance, it seems, Lord, it says insufficient address. There are 17 of them. Now, Lord, I was seeking, Lord, a direction for substituted service because it has to be complied with.
This appeal is against what?
Appeal is against refusal to pass an ad interim order. We moved it, Lord. Your lordships have been pleased to pass an interim order. And, Lord, after that, this service was directed to be affected. We have been able to serve, Lord, there are 50 respondents, out of which 17 have not been served.
Supplementary affidavit of copies on them?
No, my lord.
So it's of that copy you directly.
One thing, if may I join, my lord,
this is supplementary affidavit of service.
Oh.
Because, Lord, this is an update, Lord, of it's an update.
Updation of the original. It is something
No,
more
no,
than
right.
regular supplementary affidavit.
No, no.
Supplementary affidavit service, correctly captioned. I mean,
I got nervous.
We are convinced now why you are asking for. That would be less costly than this.
Absolutely. Lord, let's Lord, come back, Lord, after this.
The Kormakar's matters have some complication, either factually or legal. Anyway, so very well.
Milord, one thing, Milord, that the 17 persons who have stated not being served, Milord, whether those fall within the pro forma categories or because that has not been indicated. If those
None
are
of
pro
them.
forma,
No,
then Milord, Lordship, Milord,
if they are pro forma, Mr. Kormaster
because-
pointed out that.
no, because I would, Milord, my
The
clients
injunction
are
is not
otherwise,
against
Milord,
all.
are suffered with a Milord.
No permanent. Yes, we understand that, obviously, Mr. Bose. But here, the injunction is against all 1 to 50.
Yes.
1 to 50.
And they specifically not say main defendants. They say 1 to 50.
1 to 50, and whether the 17 fall within that 50.
Yes, they
They're total there are 50.
Very, very.
They have to fall within that. There's no other place to fall to.
আমরা কতজনের হয়ে আছে?
Nothing to fall back upon, as you say.
These are the persons. These are the persons have not been served. But kindly give you.
If you any of you can make them appear through some of your other. We don't know the equation here. If they can appear to someone else, if you can make that happen, any of you who are suffering the injunction, most welcome. I mean, in the meantime, let them effect substitute service. Supplementary affidavit filed to be kept. Affidavit of service filed to be kept on record. Learned senior counsel appearing for the appellant submits that although service was sought to be effected pursuant to the addresses of the parties as given in the agreement from which the present litigation emanates, the intended service, the postal articles sent to about 17 of the respondents have returned with the endorsement insufficient address. Accordingly, learned senior counsel seeks leave to effect substituted service on the unserved respondents. We find substance in such submission. Accordingly, the appellants are directed to effect substituted service by on the unserved respondents by paper publication in 2 daily newspapers having moderately good circulation in the area of the last known addresses of the said respondents and file an affidavit of service on the returnable date. Yes.
Milord, Milord, both together, Milord, are 17 out of that 15 we are appearing. 1 he is appearing. So only, Milord, effectively 11 is left. Only one. Only one person.
One is left. Why 11?
One is left now. Number 11.
There's one is left.
তাহলে যেখানে ওই আনসার্ভড বলে গেছি 17 এসব বলেছি ওখানে জাস্ট করে দাও the unserved respondent number 11 only on him.
If my learned friend takes instructions,
You take instruction, if
we
you can
can
appear
appear.
on this
Yes,
behalf
we can proceed with the matter. There is no difficulty on that.
Number 11 is left.
Only 11 is left.
The matter shall next be listed under the same heading on how soon can you effect the service. We'll keep it on 24th August after 12 days. On October 24th, 2026. Paper publication.
The only thing, Lord, Mr. Kormakar Lord points out that there is another mistake, Lord, in the cost title. There are two respondents marked as 12 and 2 respondents marked as 13.
The numbering.
Yes, it should be 12A and 13A. If your lordship kindly permit correction.
On the prayer of learned senior counsel for the appellants, the learned advocate on record for the appellants is granted leave to carry out necessary rectifications in the serial numbers of the respondents, the cause title of the memorandum as well as memorandum of the appeal as well as the connected application.
Correction permission.
So in that order, I will be appearing for 12A, 21 and 31.
12A, 21 and 31. Much of it.
Let that be corrected. You have already appeared. So
and if they
time.
My lord, I am told now that so far this defendant 11 is concerned, he is the power of attorney holder and he has taken power of the other respondents. And for whom, my lord, we
He's
shall
independently a party also.
Independently a party also.
So if my learned friend agrees,
if the principals are appearing, then
Exactly.
if my learned friend agrees, then Lord, we can proceed. There is no difficulty.
We'll on 24th just disclose that, and you have to file an independent power for him.
Very good. But instead
Power
of
means Pokalatnam.
yes, yes, of course. But instead of 24th May,
No, no, no. Whichever date we fix, we'll ask that.
well, I shall not be here.
No, no. You be here. Yes.
But I have outstation matter, madam. Please, I personally.
Give your date, then we'll keep it on 24th September then.
No, 25th August.
25th August. Very well, 25th August.
Much
August 25.
Grateful.
No. Cannot. How can it? So many matters will come and go in the meantime.
Much.
Yes.
Grateful.
Item number 9.
19 years. We have already finished the applications today.
My lord, Mr. Keshav Chandradas is appeared for the my lord applicant, my lord.
Happy to know that. Move the matter.
No, I have no instruction, my lord.
No, then you cannot have instruction to ask for time also. Unless you are prepared to start the matter, we cannot grant you adjournment. Rule in our court, particularly for juniors, you have to start the matter, otherwise no adjournment. Sorry.
But I have no brief, my lord.
Then don't ask for adjournment. You are dismissing for default. You are the chamber junior.
Kind of, yes, my lord.
Chamber junior.
Yes, my lord. Well, kind of 1 day accommodation, my lord.
We are giving you half an hour accommodation. Go through our brief and prepare yourselves. Half an hour at a passover. Come to one side and just go to the. Come to this side. Come round that boundary and come this. Yes. বাঁদিকে ওনাকে দিয়ে দেবেন একটা অ্যাপ্লিকেশন দিয়ে দেবেন উনি প্রিপেয়ার হবে
মানে শর্ট পাস হবে মানে মিস্টার সুজনজিৎ উনি অ্যাপিয়ার ইন মানে অ্যাপিয়ার ইন কোর্ট নাম্বার 21 মানে
you are for the appellant
caveator respondent
dependent is applicant
you are for the appellant
I'm for the applicant short pass হবে মানে
no what is the matter start the matter what is the appeal against what is the appeal against
মানে appeal against the
yes what is the appeal against
my lord the eviction of the licensee my lord I am the plaintiff my lord both the courts below my lord the trial court decreed the suit
we'll pass it over on the prayer of the we are adjourning for the day we won't be waiting indefinitely on the prayer of the appellants the matter is adjourned for the day comma as a last chance to the appellant to argue the matter last chance if you don't appear on the next occasion or ask for adjournment
tomorrow
goes to the slaughterhouse yes
well there is
give the appearance previous matter his appearance also yes sorry sir
two defect my lord one
what is the defect
well PML was corrected details of the my lord trial court my lord judge name and others was not input that was my lord
that has been corrected
one thing my lord judgment and degree of the trial court that was my lord, I obtained today I obtained
then we require a revised report on that because for that the sufficiency of court fee and all those report could not be given do this Mr. Das we file it in the department we are sending it back we'll keep it after a week we are permitting you to file it in the department
well, one thing my lord
it will appear we are making
my lord, execution case is going on my lord that's why my lord, we are my lord afraid of my lord there is a partition suit my lord
file it. Huh? What is the next date in the execution
14th.
Next date kobe ache?
14 this month.
This month, 14th.
No, we will take it up. File it. File the certificate. File the certificate copy.
The certificate copy?
Have you got extra copy? Another second copy. Judge's copy.
Copy.
File it. Don't nod your head.
Yes.
I have copy, my lord.
Without the brief cover.
Okay. Actually, now the appeal has been filed, my lord, only
we have to look
accompany the judgment, not degree. But degree, my lord, applied, that was not.
No, but our rules still say degree has to be filed.
Yes, my lord, our rules, my lord, provide.
If it's defective, it can't be placed under the rules
yes,
before
lord,
the bench.
That is, my lord, no, there is no dispute about it.
No, because of the change in order 41,
yes, my lord.
The appeal is no longer time barred if you don't file the degree. Previously, it was time barred also. Now it's no longer time barred. But so it's within time, but still effective. Now it's not time barred due to order 41. But without the degree, we have deliberately not changed that, Mr. Das, because otherwise the department can't furnish a report as to the names, the other things. Anyway, so let us.
My lord, here my dismissing my section application, preferring appeal, my lord. Section 5 application, my lord. If your lordship turn to section 5, I, my lord, obtain information about the final degree, and thereafter I, my lord, my lord, requested my learned advocate to search the matter, and he obtained searching report. And
how did you come to know, according to you?
Because we are in the same mess. But my lord, two brother,
You say you did not have knowledge
my
of
other
the
side, my lord.
No, you say you did not have knowledge of the suit at all.
No, not
You
so.
participate.
Final degree. Final degree, when my lord passed, my lord, only my lord Hajira was filed. And my lord commissioner report accepted and final degree run up.
Your Hajira was filed on your behalf. Then?
My lord, thereafter, I, my lord, obtain information from the learned advocate, that is the final degree has been drawn up. And my lord, I prepared an application under Order 9, Rule 13 wrongly, my lord. That was withdrawn. Thereafter, we filed the regular appeal before the learned court below. That was, my lord, accompanied with my lord, Section 5. There is a delay of 2 months, 8 days.
2 months from withdrawing that Order 9, Rule 13.
No, my lord, original order.
From the original order,
Original order.
including the Order 9, Rule 13, filing, withdrawal, everything, 2 months, something.
2 months. Rejected.
Why was it dismissed then?
Dismiss.
Section 5 not allowed, dismiss it.
Why was the Section 5 dismissed? That is what.
Well, kindly see the order. Order.
Since he was a civic volunteer, he misled the court. That was your ground. How, what kind of poor civic volunteer? They are not even paid sufficient. And they don't have the alternative means of income as the
I
police have.
demonstrate everything in my Section 5 application why delay occurred. Why delay occurred? Delay occurred only, my lord, that day, my lord, order number 16 and order date is 20th May 2026. The commissioner report without serving copy to me, my lord, the commissioner filed report. Commissioner was appointed in 2019. 2025, he filed report without serving me copy.
Your advocate was served?
No, never.
But your Hajira was filed on that day.
That is all. Usually, my lord, what happened, my lord, my trial code below, my lord, we file Hajira, and thereafter take up the matter, and without my consent, they recorded that the verbal. Well, kindly see the order.
No, why did you? The Order 9, Rule 13 was filed how soon after that?
It is within time.
Within 30 days.
Within time from the date of knowledge. Date of knowledge.
No, knowledge
is not required, but with the date of order, there is a delay.
So the Order 9, Rule 13 was filed how long after the decree?
Immediately, my lord.
Immediately means within 30 days then?
No, my lord. I have stated, my lord, in my Section 5 application, my lord. Kindly see.
2 months.
That was filed after 2 months. Then it was withdrawn and then this is filed. So total delays?
Total delays 2 months,
8
days from the date of order.
Yes, Mr. Chakravarti, what do you say?
What is the?
It's for the appeal itself we want it for.
No, I would not. Otherwise, what is the? There is findings of malafide in the application. No, kindly come to Milord page 1440 onwards of the
The application.
annex here. What is it? Page 40.
14.
Page 40.
40.
40. Last 5th November 2014.
Yes.
Commissioner filed his report.
Right.
Commissioner filed his report. Maybe after 2 years or 3 years, filed and delayed was.
Commissioner was appointed 2019.
Everything starts. Anyway, that is not the issue here. Then next page, kindly see. Order dated 21st January 2025.
Yes.
Plaintiff filed Hajira with fresh Vokalatnama. Let it be kept with the record. Defendant filed Hajira.
Yes.
Then the matter was fixed for 20th May 2025 for acceptance of commissioner's report. Therefore, his learned advocate of both sides are present. He acknowledged it is his, yes, Section 5 application, the explanation chart. I had no knowledge of the filing of the partition commissioner's report. I have no knowledge of the passing of the final decree. And my learned advocate never appeared on the day of passing of the final decree.
And both of them,
give consent.
their lawyer also submitted, they have no objection.
No objection.
That is my lord.
That is
I
recorded.
also,
That is
my
the-
lord,
that is
I
the order.
also requested the learned advocate to file an application before the learned court below that I never consent.
Never consent.
Never consent.
Who says this? Not the defendant said
The learned advocate never does not say so. And he
Why
filed his
I
application-
agree? Why
he
I
filed his
agree?
Appeal by a separate advocate before the appeal court.
Why I agree?
It is the knowledge of the learned
my retained position, my lord, has been allotted to the plaintiff.
That is the ground.
The partition,
The
my lord,
allegation
proves
is
that
against
the
the
retained
defend-
position cannot be, my
against
lord,
the
altered.
Respondent that he has misled the court. No, this is a bald allegation, my lord. No evidence.
On merit, appeal would
How
be
can
hard.
you mislead, my lord? Learned advocate
So this is, there is some doubt if the allocation was unequal in his perception. Two things. One is that there is nothing on record to indicate that a copy of the
Yes.
commissioner's report was served on either him or
But he has knowledge.
No.
Maybe, sir,
so
record
knowledge of the
it does not, sir.
knowledge
It
of the
was not
date
served.
of the suit of the advocate is
Record
not.
does not say it is not, sir.
So Chakoti, let us complete our sentence. Otherwise, how can you answer? The trial court, in the present impugned judgment, the appellate court does not consider this fact that whether the advocate was given any authority to specifically concede to the commissioner's report, and whether any copy of the commissioner's report was at all served on him or his advocate. Without service of a copy, how could his advocate concede to the report also?
But
Whether he had the authority to so concede.
He gave his consent to the accept. Otherwise,
Advocate
unless,
gave.
unless
Whether the advocate had authority to give that consent, Mr. Chakoti, that's very important. Giving a no objection is very fine.
he's holding vocal
It's not a question of law that I concede on law. We can understand that.
Yes,
Which is not binding on parties.
under
But
section-
there are several judgments of the Supreme Court also on fact. If you give a concession, there has to be specific authority to do that.
He's holding vocal of the
And to shut him out only since he came after 2.5 months, by holding that it's malafide. How do you know it's malafide? Then there had to be recorded proof that no copy of the commission's report was given. And the advocate,
Otherwise,
these are two foundational facts.
given
which
the
are-
consent.
There are two foundational facts, Mr. Chakravarti, which are not considered in the judgment. One is that advocate, they were given copy of the commissioner's report in the first place. To give a no objection, waiver has to be a conscious relinquishment of a right. There is no conscious element about it without a copy of the commissioner's report. Secondly, whether the advocate has authority to give a no objection to the commissioner's report. His share is being compromised, not the advocate's share.
But advocate is
And
holding
2 months and some days delay, 8 days delay.
Same advocate does not say so. Different advocate.
Did
He
not
filed
the-
a appeal. he
as we
said
direct
it in
notice to be
section
served on the
5
erstwhile advocate,
in
that
appeal.
could have been done. That could have been done. Their allegation is it's virtually an allegation against the earlier advocate. Court could have directed the earlier advocate to be served and hear him. No difficulty there also. We do that in our court. You know that, Mr. Chakravarti. Whenever there is a specific allegation against the previous advocate, we direct copy to be served on that advocate, so that that person has a right of hearing. That could have been resorted to by the trial court, appellate court. How do you say malafide?
Thing was to file an application.
See,
before
we
the
find
Supreme
these
Court,
raise a
152.
question
If
of
it is wrong recording, but in case of wrong
very well we are admitting the appeal there.
they may be given liberty to file approach the same court under section 152. They could have
No, we
got correction.
intend to do
Actually,
nothing.
otherwise, no.
We intend to do nothing of that sort. How is it malafide?
Malafide because the allegation is my client is a civic volunteer. Maybe he's.
They alleged your malafide that which was not proved.
They say that's why he has misled the court. That's why
Malafide.
it is a casting aspersion on the court itself.
Then no allegation can be leveled in any plaint or written statement, Mr. Chakravarti. That is to be accepted. In every other plaint, there is an allegation against the other side, political influence, this influence, that influence.
Not bona
Then
fide because
we cannot take notice of these
he himself
averments to say
appeared-
malafide. How is that malafide? Malafide has
bona
to
fide,
malafide has to pertain to the delay, Mr. Chakravarti, not in his
not bona fide-
allegations. This is not a matrimonial suit.
bona fides of the allegation was disputed. Court has disbelieved.
Not bona fide does not necessarily mean malafide. There's a gray area in between. Something which is not bona fide but not malafide either. Malafide has to be positively asserted. So we are admitting the appeal and then keeping the appeal pending, directing paperwork to be served. Or if you agree, we'll just dispose of this and send it to the appellate court to be heard on merit. It's your choice, you decide.
But,
He is also there, Mr. Sinara.
no. The client is not
He's
there.
appearing
That's
after a
why I
long time.
cannot take instruction.
Take instruction, come back on Monday. We're keeping it on Monday. We're not saying so much.
Execution.
The certified copy of the trial court's judgment and decree and the second judge's copy thereof filed today be kept on record. Full stop. the office shall shall furnish a further report in that regard after the matter is heard on the returnable date. Who's the next para? Other defective classification. We take note of the fact that the preamble of the memorandum of appeal has been appropriately, no, name of the judge is still not there.
Yes.
Trial judge's name is not there. No, passed by learned civil judge, senior division. Second, leave is granted to the learned advocate on record for the appellant to insert the name of the presiding officer of the trial court in the preamble of the appeal before the returnable date. Full stop. The matter shall be listed under the same heading on August 17, 2026. The name of the learned trial judge has to be given. Name of the trial judge.
Yes, my lord, I start.
Certain other things have been inserted. এটা এখন নামবে না আমরা বলেছি পরে রিটার্নেবল ডিটেইলস শোনার পরে তারপর
The matter will returnable, my lord.
Monday under 7
Monday, my lord. 14 is the date, my lord. Execution.
But we don't take up order for 10 matters before that. Huh? Today we are on 12th. Yes, cite the pendency. Give us server copy of this order. No executive court will proceed.
Well, liberty is given, my lord, to file my lord, adjournment before the
admission
execution court. Usually, my lord, we, my lord.
No.
Only server copy will do.
Not in a second appeal where it has not been admitted under order for 12.
Yes, my lord. I
In the first appeal, you could have given that liberty. No admission is required. You have not crossed the threshold. Not crossed the threshold. Yes, who is appearing in this?
This is my application.
Yes, Mr. Naik.
Within time, no caveat, my lord. My lord, this is against an order, my lord. I'll be very candid right at the beginning. One of those rare cases, my lord, where I have been granted everything except for what I needed the most.
Okay.
In a suit for partition, lordship need not be troubled with the papers. I'll just take 1 minute, my lord. In a suit for partition, I file, my lord, I'm the plaintiff in the suit. I file an injunction application. Naturally, to protect my possession till the suit is decided, 50% joint holder of the property, undivided proportionate share, it's an admitted possession. One of the contentions in my plaint and my order 39 rule 1 and 2 application was that one of the rooms inside, my lord, the house where the water pump is located, and one of the two doors, both these have been padlocked. My injunction application expressly, amongst other prayers, which is for protecting my possession, prayed for my ingress and egress into those two rooms. So that
2 rooms, why 2 rooms?
One is the water where the water, one is the water pump where the water pump is, the other is the main entrance. The back entrance I have access. Admittedly, but I'll not make a better case.
The main entrance is to a room.
No, the main entrance to the house.
So that has been padlocked.
That has been padlocked. And the other door I have access to. And when I enter through the other door, once I go in.
So you sought an ingress and egress, protection of ingress and egress to that main door and to that room.
And to the room which is already inside the house. So very candidly speaking, I have access inside the house. I want access to the main door which I'm entitled to because I'm a undivided proportional 50% holder of the property. That I asked for and the door inside. Now, in the impugned order, contested, impugned order which has been passed, the trial judge holds in my favor. Holds that I have been able to establish prima facie case that I'm a 50% undivided proportionate shareholder in the property as an owner. Grants me the two reliefs with respect to status quo as to possession, but my lord omits to grant me the relief with respect to ingress and egress. Well, this is the limited scope of my appeal, my lord.
Sub copy, you are admitting the appeal. Sub copy of the memo as well as the application will take up the appeal along with the application.
Well, all my documents are a part of my application.
Yes, we'll record that. In view of arguable questions having been raised, the appeal is admitted and shall be heard on the grounds taken in the memorandum. Full stop. Next para. The appellant shall serve copies of the memorandum of appeal as well as the application on the respondents. Respondents were represented through counsel, obviously. Respondents, either directly or through the learned advocate on record appearing in the trial court. And file an affidavit of service to that effect on the returnable date. Full stop. It is made clear that that such notice shall be deemed to be a notice of hearing of the appeal as well. Full stop. We intend to take up the appeal along with the application for hearing on the returnable date. Full stop, the matter shall next be listed on August 24, 2026 under the same heading. Better to serve a server copy of this order along with this.
We shall.
That will be. আচ্ছা যেখানে বললাম না serve copies of memorandum application as well as a server copy of this order. So that will be treated to be a notice of the appeal as. Oh. Under the same heading na kore under the heading application. Thank you.
Only one small parameter. At my prejudice, I'm putting this question to myself. I'm taking the benefit of the order that has been impugned by me before this court. Lordship may clarify that till the.
You have not granted his stay.
No, that I cannot also, but not required.
Convince him. It's your task, not ours. Yes.
Item number 23.
Yes. What is the matter?
Last question, my lord. File one supplementary affidavit, my lord.
Defect has been cured. There was a defect, some defect is there.
So there is some annexure with the, my lord, injunction application under order 13 rule 1 2, my lord. That annexure was not there. So your lordship liberty is given to supplementary affidavit that.
Yes.
Lord, this
What is the appeal against?
Appeal against, my lord, order of, my lord, injunction application as well as, my lord, order 13 rule 4 only jointly.
In what suit?
Suit for specific performance of contract.
What is the difficulty if injunction has been rejected? No, injunction has been allowed.
My lord, there is
If you
no
create a third party interest, what will remain in this suit?
no, my lord, there is, my lord, no agreement, no earnest money, no agreement has been signed. Only, my lord, broker communication with the plaintiff to sale of the property. There was some communication on WhatsApp message. Then, my lord, send a mail, my lord, draft copy of agreement. There was nothing. Now, my lord, plaintiff filed this suit that there is a consideration money 65 lakhs with the broker through acceptance that, my lord, now, my lord,
Any
order has
proof
been
of that payment has been
no, nothing. That is, my lord, plaintiff also admitted there is no payment.
Admitted there is no payment or no
Yes.
document of payment.
Yes, no payment. Plaintiff also stated there is.
Let's see how it was dealt with by the trial. Page 2 থেকে general principle গুলো কোথায় আছে? Last paragraph page 2 থেকে reasoning. তার আগে break করো। Draft agreement was produced by them.
Or sent by the plaintiff to mail.
By themselves?
Yes.
To whom? To you? No, it's the order records and further title documents and specific draft agreement annexure F were shared from the side of the defendants.
Yes, they have.
You had shared a draft agreement.
No, not this appellant. There is a joint property, brother and sister. They have sent draft to the brother. This appellant, sister have no connection with the selling of this property or not contact with the broker or anything.
We're admitting the appeal is soft copy and come back. But at this stage, if you stay the operation, then that would be.
No, there is a plain, they have stated, no money has been given.
You can't stay at this stage. That will be allowing the appeal.
Kindly similar plain.
Let them appear, we'll consider.
Only stated, there is some communication through broker. There is a senior citizen this property of the owner.
Draft deed was sent
Draft
by some
agreement,
of you.
not draft.
Sorry, draft agreement was sent by some of you.
There is no sign, no payment. Claimed also they have stated no payment.
So draft agreement an agreement is the value. case আছে. You have made out an arguable case. We agree with that. But at this stage, we cannot stay the operation. That will allow the appeal before hearing them. Serve copy and come back quickly. How soon can you serve? Serve only on the plaintiff because other defendant need not be served. We find a strong prima facie case for hearing of the appeal on merits having been made out. Accordingly, the appeal is admitted and shall be heard on the grounds taken in the memorandum. The appellant shall serve copies of the memorandum of appeal as well as the application on the plaintiff stroke respondent 1, indicating that the application shall be listed next on August 2026, when an affidavit of service to that effect shall be filed by the appellant, in view of the relief being primarily sought against the plaintiff stroke respondent 1, service of notice of the application and the appeal on the pro forma respondents 1 and 2 and 3 is dispensed with. Serve a notice if they appear on the next day to supplementary affidavit filed to be kept on record. যেখানে বললাম যে serve copies of application, supplementary affidavit and memorandum. Let them appear if we find it, we'll hear them. If we find it necessary, we'll dispose of them. Yes.
My lord,
Yes.
this is my appeal, my lord, and for the appellant.
What is the challenge against?
My lord, this is a Devottar property and the my lord Shebite applied for the sale of the particular property. My lord, the order sheets are annexed to the memorandum of appeal.
What have you challenged here?
My lord, in FMA, in the miss case number 311 of 2006, two order was passed.
331.
331 of 2006, three order was passed. One order is
This case was under which provision of law?
the under 34 of the Trust Act.
Achha.
My lord, I'm coming. I have challenged the order number 76.
Yes.
But before that, my lord, I'm
is an appeal mandatory? This is not a regular suit. It was registered as miscellaneous case. Has the trappings of a suit, but a summary procedure sort of. Is an appeal maintainable? This is not under
it
order
should be
39
a first
one and two.
miscellaneous appeal, I think.
Miscellaneous appeal, order 43 says passed in a suit.
Yes.
Order passed under order 39 rule 1 and 2. 39 1 and 2 deals with suits.
Yes.
Miscellaneous case, suppose in an order 9 rule 13 application, if you get an injunction or an injunction is refused, that's not
Injunction,
appeal.
no, there is no question of injunction, my lord. First, I have prayed for the sale of the property and it was granted to me by an order dated 6 January 2014.
You have not challenged an order of injunction before us.
Yes, the order of injunction has.
So that order of injunction has been passed in respect of not a suit, but a miscellaneous case.
Yes.
Therefore, it is not covered by order 39 rule 1 and 2, which contemplates only injunctions passed in suits. So therefore, whether order 43 applies at all, 227 is the appropriate remedy, Mr. Sinha.
My lord, kindly keep it.
Yes, you satisfy us on that. Yes. Probably, even if that is maintainable, we immediately grant you leave. No doubt. Obviously, we have to. Yes. You cannot shut your rights. But still, you just satisfy us. If you find that appeal is maintainable, fine. It has the trappings of a suit. We agree with you. But it's registered as a miscellaneous case. That's why we asked you what provision. In order to enable learned counsel for the appellants to satisfy the court as to maintainability of the appeal, since the impugned order of injunction was passed in connection with a miscellaneous case, the matter is adjourned till Monday.
Monday.
Is adjourned till August 17, 2026, when it will next be listed under the same. Next.
I am for the appellant.
Yes, suppose you are for the response. For the response.
Okay.
For the other appeals are against the extension orders.
Extension.
Good. Which is the main appeal? We'll take that because that. First one is FMAT. FMA.
Item number 25.
FMAT 213. FMA number.
FMA 816.
816. 816 if I tell you. এটাই উপরে আছে এখানে দুই নাম্বার হচ্ছে এখানে প্যানেলে indicate করে না ওরা anyway very well yes what is the matter Mr. Bose
Before your lordship takes up the papers, this suit relates to an association of owners of apartments in a building known as Sunrise Towers. Now, plaintiffs, surprisingly, is the association and three persons.
FMET নাম্বারটা হচ্ছে তো what
My lordship needs the FMAT number.
no we have got it yes একদম তলা চলে যায় মেমোটা দেয় একদম তলা চলে যায় FMET কত 816 ওটাই উপরে 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 একদম এই লেখা ছিল এটাই yes please carry association is the plaintiff
Association and three persons who claim to be its or who were on the date of filing of the suit, its president, secretary, and treasurer have filed the suit. Now, the series of events is the members of the association get to know that a suit filed by the president, who is the plaintiff number 3, has been compromised by the association by filing a compromise petition in a suit in Shialda, where the president signs as the plaintiff and the secretary signs as on behalf of the association. They compromise the suit without any notice to the general body of members. On coming to know of that, apart from other legal steps that have been taken,
suit was against whom
the suit was by the association against the person who is now the president, initiated in 2019. The president had filed the suit against the association. Current president filed the suit against the association in 2019. After that, he got elected to the board. In his second term, he has now got the secretary to execute a compromise along with him in that suit. Now, the compromise is not in
prior to his becoming a president
the suit was filed prior.
compromise was effected after
Yes, compromise is in 2025. When we come to know of this in 2026, apart from whatever steps have been taken in Shialda to have the compromise decree recalled, we requisition a general meeting, special general meeting.
that compromise was in respect of what sort of a compromise
This
Regarding
man,
the membership
this
of
no,
portfolios?
this I'll tell you, lordship. That is not going to be an issue here, but I'll just give you, lordship, the background. He was the owner of one flat which was held by his wife. He purchased another flat in an auction. That flat had CAM dues, common area maintenance charge dues. The association filed a suit against this gentleman and his vendor and the bank, saying that you all have transacted in the property keeping the CAM due. So any of you are liable to this, you have to pay the money. He files a suit in 2019 saying, declare that I am not a defaulter, obtains an ad interim order of injunction saying that he should be given a no objection certificate and he can exercise all rights as a member. That suit is compromised by confirming the decree of temporary injunction into one of permanent injunction, leaving the fate of the money suit open. Now we file a notice for special general meeting. A special general meeting is requisitioned in terms of the Apartment Ownership Act. The board, which comprises of these three people, rejects the request, although one of the requests is the removal of the president, secretary, and the treasurer for effecting the compromise behind the back of the general body. When they refuse to call the SGM, then in terms of the law, we convene the SGM. After we convene the SGM, the competent authority on 27th of May passes an order saying, since the annual general meeting of the association is already on 31st, and you have called the SGM on the 30th, there should be a clubbed meeting on the 31st. The agenda of the SGM will be taken up first. The president will not preside over the meeting because the president is being sought to be impeached. A suit is filed on the 29th during the vacations in the Civil Court in Calcutta. An application for temporary injunction is moved. It is rejected. No appeal against that order.
Injunction restraining that meeting.
To restrain that meeting. On 31st, the meeting is held. At the meeting, the resolution, and this would be an important fact, the resolution is carried by 64 votes to 1. Removal. Out of 79 attendees, 65 voted on that resolution, 65 valid votes, 64:1 is the majority. On 1st June, an application is moved under section 94E, saying that there has been a meeting, the meeting is illegal.
The same suit where the injunction
In the
was
same
declared?
suit, without amending the plaint, a 94E application is moved. The prayer is, we don't know what has happened. There is resolution has been taken. No effect should be given to the resolution. The order is, that order is not passed. The order is, these 4 defendants are restrained from convening any further meeting.
All right.
So, number 1, and the 94E application is being filed not only by these 3 people who have been removed, but also by the association and by these people representing that they are the president, secretary, and the treasurer. Now, I had, in the appeal, my lord, I had 2 very simple points. Whether in light of the prayer sought, the relief granted could have been made. And if I have since the SGM has been held, any further meeting would require a further notice of an SGM. So if I today become part of another group that tries to convene another SGM, can the court impose a blanket bar on me from holding such an SGM or meeting?
You are not portfolio holders.
No, I am not a member of the board. I am a general body member.
All right.
Now, what happens is, after that order is made and we file our written objection, in the meantime, the appeal has been preferred, 2 extensions. On 6th of August, the competent authority, being a party to the suit, having not filed either a written statement or written objection, comes up with a order which contains several directions, of which 2 are material. That is what we have brought on record by the supplementary affidavit. The competent authority nullifies the resolution by saying that you permitted defaulters to vote on a resolution for removal, and that is barred under bylaw 11. Now, she is conscious that bylaw 11 only bars me from either standing for election or voting at an election. It does not bar me from participating in a resolution of removal under bylaw 10, because election is under bylaw 8. I say, before I even have to go into that, in the direction, she says all the resolutions passed on 30th May become invalid. No meeting was held on 30th May, because the meeting was held on 31st May as per the order of the competent authority. So effectively, the directions have no effect, because they talk about resolutions or at a meeting held on a date when it was not held. B, even if even if we treat it as she meant the 31st, it is completely dehorse her jurisdiction, because she can't sit in appeal over the judgment of the general body. Number 1. Number 2, the statute does not use the word removal in bylaw 11. I will just place the bylaws, but I just want to first take your lordship to the prayers in the plaint first. Kindly, my lord, take the plaint.
What are you challenging? The 94?
No, the order under 94. Kindly come to page. The plaint is at page 189. The prayers are at page 222 in volume 2, my lord.
Yes.
First leave is order 1, rule 8.
You are Mr. Shreyan Bhattacharya, aren't you? No, Lord. Mr. Basu, his name is Shreyan Bhattacharya. So you have a weakness for him. You may lose this case. Otherwise also, on merits also. That comes second. It's the name of my son, that's why.
I know.
Anyway, yeah. So page 222, yeah, right.
First is leave under rule order 1 rule 8. Plaintiff is presented, this leave is not granted. Leave under section 82 granted, then decree for declaration declaring the purported notice dated so and so issued by the defendant number 2 convening a parallel special general meeting is illegal, fraudulent, ultra vires the West Bengal Apartment Ownership Act. Next, decree for declaration that the order dated 27th May 2026 passed by the defendant number 1 is illegal, arbitrary, and then consequential relief of injunction.
Yes.
Now, let kindly take the prayer in the application and for order 39 rule 1 and 2. That your lordship will find. Your lordship will find the application at page 228. The prayers are at page 263 in volume 3.
Same volume.
In volume 2. In volume 2.
Yes.
Order of temporary injunction restraining the respondent number 1 from in any manner giving effect to acting upon, implementing, enforcing on, relying upon the order dated 27th May and from convening, holding, organizing SGM. This is refused and they don't prefer an appeal from this. Now, kindly see the application under section 94E, page 378, volume 3. And the prayer is at page 389.
One second, let us just come back to that, what was refused. Giving effect to that.
Yes. Giving effect to the order of the competent authority clubbing the meeting and restraining us from holding the meeting. Now, page 378, the application under 94E starts. Page 390, 389, the prayer portion starts. Now, before the prayer, Millard, kindly come to paragraph 22. At page 388.
Right. Could you release the other matters besides?
Yes, 15 minutes.
Other matters are released. Yes.
15 minutes are left.
We can't look any longer at the pensive faces at the end of the day. Other matters are released. Yes. Mr. Basu has also gone. His matter is going on.
Lord, he has taken my lord's leave. Lord, he has a.
He has not taken leave from the court.
See,
Did not. Would have to take leave from us. He did not.
I shall intimate. He will be back in a moment.
Definitely, yes. Do whatever you need to do.
We were pensive, he was expensive.
Fantastic. Yes.
Under the circumstances stated above,
Yes.
and without prejudice to the primary rights of the petitioners to challenge the foundational validity of the main order dated 27th May 2026, the petitioners submit that the ground realities of 31st May 2026 demonstrate that the competent authorities' directions were utterly defeated and flouted by the rebel faction. Therefore, it is most humbly prayed that taking judicial cognizance of these flagrant violations, this learned court may graciously be pleased to pass an immediate ad interim order against the respondent numbers 2 to 5, not granting any recognition, legitimacy, or giving any operational effect and or further effect to the resolutions, elections, or minutes purportedly passed at the fractured assembly on so and so till disposal of the suit. So the fact that there is a resolution is tacitly admitted. And now kindly come to the prayer. Now kindly take the prayers. In the circumstances, it is most respectfully prayed that your honor may graciously be pleased to pass an order and thereby, by taking judicial cognizance of these flagrant violations as stated in the petition, this learned court may graciously be pleased to pass an immediate ad interim order against the respondent numbers 2 to 5, restraining each of them from granting any recognition, legitimacy, or giving any operational effect and or further effect to any resolutions, elections, or minutes purportedly passed at the fractured assembly till disposal of the suit, and pass such other or further order as your honor may deem fitted in the interest of justice. Now, my lord, the order impugned, if your lordships now kindly take the memorandum of appeal. Record, lordships.
Oh, it just now. What is the date of that order?
1st June 2026.
The memo, we don't find it. Certificate copy.
It should be
Did
there.
we,
My scanned copy shows. I have
yes, it's there in my brother's copy also, but did you grant you exemption from filing it certified copy? No, but these are the different orders. Please check up just once, sir. Maybe I am missing something. That's something else. No, this is the memo.
This is not the extension.
No, sorry. Yes, that is the extension. Right. Sorry, got it.
Record is taken up today in view of the put-up petition filed by the plaintiffs since they want to move the application under section 94E read with section 151 of CPC. Heard learned advocate for the plaintiffs petitioners in respect of the above petition. By filing this application, plaintiffs petitioners mainly contend that on 31st May 2026, around 11 a.m. at the community hall of Sunrise Towers, an attempt was made to conduct special general meeting and annual general meeting strictly in terms of the order dated 27th May 2026 issued by the competent authority. In terms of the direction of the competent authority, the above meeting should be presided over by the senior-most member present, who shall be the chairperson of that meeting. Mr. Shrikant Gupta, aged about 72 years, is the senior-most member of the society. He was also willing to conduct the meeting in terms of the direction of the competent authority, but he was removed from the chairpersonship of the defendants illegally. Considering the annexures of the application, specifically annexure Y1 written by Shrikant Gupta dated so and so, it appears that Mr. Shrikant Gupta was deliberately removed to conduct the meetings as per directions of the competent authority. Therefore, this court is of the opinion in the present circumstances an interlocutory order should be passed to prevent the ends of justice from being defeated. Accordingly, application is allowed. This is ad interim, ex parte. Defendants are directed not to conduct any meeting. Defendants are directed not to conduct any meeting till 26 June 2026 in connection Sunrise Towers Apartment Owners Association. The tenor of the application is that the meeting has been held. So if the meeting has been held, what am I being injuncted from holding, and what order is this going to be enforceable? Defendants are at liberty to appear before this court within so and so to contest the injunction application as well as this application. So application is allowed.
This was without notice to you?
Yes. Application allowed. I can come and contest the application after it is allowed.
Yes. Do that. It will be an interesting exercise.
Now, my lord, 3 grounds taken in the plaint. Now, my lord, may I take your lordship back once again to the plaint, because the foundation has to be the plaint. Basic case run in the plaint is that A, the board is supreme the board is supreme, the general body is subservient to the board. Defaulters, the primary ground of attack is.
Don't find even so many reasons in the first of
There
all,
is no reason.
appears to be unreasoned, very unreasoned. Secondly, relief is beyond the prayers.
Yes.
And thirdly, that previous refusal of injunction after that, whether in the garb of 94E, another injunction could be sought.
39 rule 1 and 2 once rejected, 94.
And
this
then
is a dangerous trend that your lordship will now find.
That has been happening since long, you know that. But the difficulty is now it is, yes, you are right. Now it is becoming a fad. And secondly, also, I mean, this res judicata operates at the same stage of the proceeding.
Yes. Now, but just to meet all other points on merit, your lordship has already taken all the technical points that I would have taken anyways.
Yes.
But the on merits,
Hmm.
kindly take the Apartment Ownership Act, my lord, and the bylaws.
কোথায় আছেন দীপঙ্কর, কখন বেরিয়েছে?
কোথাও একটা ঢুকে গেছে।
Yes, bylaws. You'll be showing the bylaws or?
Bylaws.
Bylaws.
Kindly first come to bylaw 4. And I show your lordship bylaw 4 and I show your lordship one paragraph in the plaint. The entire premise of the plaint is contrary to bylaw 4. Powers and function of an association.
Yes.
The final authority of an association shall vest in the general members, who shall exercise such power through general meeting of the association, and they shall administer the property concerned in accordance with the act and these bylaws, and exercise general supervision over the affairs and business of the association, and in particular over the activities of the board. So, my lord, general body supreme, general body will supervise the board. Now, kindly once take the plaint. May I trouble your lordship once to the plaint. Printable কত কথা?
189.
Page 189. Kindly take paragraph 2. The plaintiffs state at page 192, paragraph 2 at page 192. The plaintiffs state that the current and subsisting board of managers of the said association, comprising the president, secretary, treasurer, and other duly designated executive members, are the lawfully and officially elected representatives of the association, whose authority is binding upon all apartment owners and stakeholders. No, it can't be. It is the apartment owners and the stakeholders whose authority over the board is binding. The election, constitution, and continuance of the present board have been conducted strictly in accordance with the mandatory statutory provisions, so and so. So, the fundamental basis of the plaint is that the board is supreme and controls the members. Now, let kindly see bylaw 11, since that is going to be the main crux. Disqualifications for being managers.
Yes.
Any apartment owner, the first is the marginal note. It's disqualification to be a manager. Any apartment owner who fails to pay in any financial year any installment of his contribution towards the common expenses which may have been assessed by the concerned association shall not be entitled to vote at any election of the managers of the board concerned, and to seek election for the office of the managers of the board concerned till his arrears are cleared. So, very clear.
So, refer to that decree which you say to be collusive.
Yes.
So, by virtue of that compromise, he's mitigated his,
yes.
But otherwise he's liable.
Yes. Now, at the time when he got elected in 2025, he was saved by an order of temporary injunction obtained in the suit, which said that he should not be treated as a defaulter. Now he has converted that by the compromise into a permanent decree, into a decree for perpetual injunction. Now, what has happened in the SGM is what is covered by Rule 10, Bylaw 10, removal of managers. A manager may be removed from office at any special general meeting of the association convened on the requisition of the board by a vote of the majority of the apartment owners present, and thereupon a successor shall be elected within 6 weeks through a special election. The manager so elected shall remain in office for the residue period of the manager on whose removal he has been elected. Now, there are two parts to this. One is at a special general meeting.
But manager and president have been distinguished in bylaw 9. A board shall meet at once a month, and its meeting shall be presided over by its president and in his absence by a manager.
Correct.
This refers to
Manager,
manager.
president is selected out of the managers. I'll just come. May I just place it?
So if you say the manager, if the manager can be removed, president is covered as a subset.
Yes, president is, you have to first be a manager.
Yes, very well.
Namarad,
right.
This is 10. 10 has two parts. One is the removal from office at an SGM. And thereafter, a manager will be elected. Now, how will the manager be elected? The manager will be elected in terms of bylaw 8. So, disqualification of bylaw 11, A does not lie so far as calling a SGM or participating in an SGM, because it only talks about vote and seek election. Nothing else can be read into this.
No, you mean to say what? I mean, who was disqualified here?
Their case is that some of the requisitionists were defaulters, could not have issued the notice and could not have participated in the resolution for removal. So removal.
So this 11 disqualification does not apply to
removal. 10
general body meetings and
10.
removal in
Correct. Only I can't stand for election, I can't vote at an election. Now, election also, your lordship will see, is covered by a separate bylaw, which is bylaw 8.
Yes.
So what 11 seeks to do is provide a qualification or a disqualification for what is conceived by 8 and nothing else.
All right.
Now, this is from the ad interim state, so I will not want to take your lordship on what my case is to the opposition, but just in view of the order of the competent authority, kindly also keep in mind that even if we take away all the defaulters, that is 17 out of the 64 whose votes were valid for this resolution were defaulters, the remaining 47 were not. Now, I'll kindly take the supplementary affidavit that we have filed. Because although this was not there on the day when the court passed the order, I am sure this will be cited to show that these appeals have been rendered infructuous. Page 10 of the supplementary affidavit.
Yes.
Whereas this department received grievances regarding the administration and proceedings of so and so. This is the narration. Kindly come to the last paragraph on that page. Whereas bylaw 11 strictly restricts any member who is a defaulter of lawful dues from voting in elections or contesting for a post in the board of managers. Up to here, she is correct. Accordingly, in exercise of powers conferred under section 16B1 of the Act, read with bylaw 39 of the West Bengal Apartment Ownership Bylaws, this authority hereby issues the following directions. Any validity of resolutions in meeting dated 30th May 2026. Any resolution, I can stop here. Meeting dated 30th May. There was no meeting on 30th May. Any resolution passed in the AGM or SGM dated 30th May 2026 concerning the removal of office bearers or members of the board of managers where votes were cast by members listed in the official defaulters list shall be deemed invalid and non-est. Now kindly mark this, my lord, she is a party to the suit. This is virtually deciding the suit. Restriction on defaulters. In any general meeting of the association, Apartment owners.
No, he's hurrying up because it's going against him.
Any general meeting, AGM or SGM of the association, apartment owners who are in default of lawful contributions or dues shall be permitted to attend the meeting. However, they shall be strictly prohibited from voting on any agenda item dealing with election of members to the board of managers, no problem. Removal or recall of any office bearer or members of the board of managers. Where does she find this in the bylaws? And Malad, the question would be whether by taking recourse to power to remove difficulties, you can invalidate a resolution at a general body which is supreme.
16B powers also, the core of the power.
I'll come back.
We'll continue. But we have to come back on Monday. only.
Monday.
Although the matter is substantially heard, we're admitting the appeal and we'll
Your
take up
Lordship
the
has
appeal and
admitted.
the appeal.
First appeal, Your Lordship has admitted. The other two were not in the list on that day.
Okay.
So Your Lordship can admit those two and
So
place this as applications.
60, 26 আর 27টার আইটেমগুলো এফএমএ নাম্বারটা দেখে নিও ওইগুলো নাম দিয়ে এফএমএ such and such are admitted to be heard along with FMA 816 of 2026 pushed up in view of the issues raised in connection with the interim application being identical with the appeal. We intend to take up the appeal itself for hearing along with the application on August 17, 2026. We'll give it on August 18. On August 18,
17, may I have the liberty to file a response to this application?
Then we'll keep it after that, 1 week after that. On August 25, 2026, when the matter shall next be listed under the same heading. To retain its position under the application heading, but we'll hear
No,
it.
this is appearing as order 41, so it should appear as
Oh,
application.
sir. Sorry. Under the heading application. Under the heading application, Pushap, affidavits, if any, shall be exchanged in the meantime. Mr. Basu will try to give a
Yes,
copy
I will.
as early as possible.
Just digressing for a moment, Your Lordship said it has become a fad. The latest fad is you get served in a suit, and after 2 months you come and file an application that I've not been served the annexures. It's a standard application now. Every suit.
I've not got a copy of the annexures.
Every suit.
Oh, that's it.
First day appear, say nothing. Next day come, I have not got a copy of the annexures. Please serve me again. It's a plaintiff with 300 pages with annexures. You can see the weight.
Yes.
But it is better not to fight and you have to give 1 second.
You have got a copy of the annexures?
I have.
Have you informed Mr. Basu? We expressed our reservations regarding his leaving the court without leave of the court.
I didn't get the opportunity.
Indicate.